Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican po I didn't ask you to interrupt me.
All right. Order in court, order. Everyone please be seated. Welcome to the Court of Public Opinion. I'm the Recovery Addict. Welcome. Good to have you here. Thank you for being here as well. Not sure where to put my gavel. Need it handy in case you guys get out of hand a little bit, but just also need my space. Good Friday Eve, says Amanda. Amanda, yes. First, I have to say I just clicked off the screen and made a mess of it. But Sharon McDonald, our CEO of the Internet, is back in charge today. Everything is under control. Don't worry. She's got it covered. I appreciate that, Sharon. Thank you so much for being here first in chat. Bring the jury. We have some good stuff today. We have a lot to cover. We have updates on the hearing we heard yesterday for the Petito Laundrie case, or as every time I say it, the closed captioning seems to catch it as Potato Laundry. But Petito Laundrie is the case that we followed. The civil case, the hearing from yesterday, it went a little bit long at points, but some major progress was made. So we have some information. We're going to go over the letter that was admitted in, that was allowed in, that was fighting so hard. The prosecution was fighting so hard to not turn over to the defense. We're going to go over that letter. We're going to go over the response from that letter, or the affidavit that was entered by Roberta Laundrie, the author of the letter, when that first broke. And also we're going to go over her latest statement about that letter. Then, in addition, the folks back at the Family Feud trial have started to get their act in order, and they just dumped 3 sections of videos on us. They have been filming all along. They've just been editing and putting it together. The good news is it's a little bit shorter. The breaks are cut out in many cases. It's easier to follow. We can, in theory, catch up if they would dump it a little bit faster. But we have enough that we can continue following. We have the remainder of the day that we heard the morning of. We have the remainder of that day, and we have all of the next day that has been released. So hopefully we're just a little bit behind. Now that video's out, it looks like it's going to continue coming out. It seems to be I would not have this pool photographer be the same pool photographer in the future. I'm just saying. That's just me. It seems we'd like it released a little bit sooner, but it is what it is. The judge is allowing what they have filmed. It's better video. We get to see some witnesses in this next segment, and I think we're finding our happy place. So we have that. That is exciting. So we're going to have that this morning as well. Let's see. There's a lot of people in chat talking about the Karen Reed case. The Karen Reed case, which is fascinating to me for a couple of reasons. You know that I like trials that have elements that we have not seen before. And in this particular case, we have a police officer who was found dead, bruised, broken, bloody, frozen on the lawn of a fellow police officer's house where a party had occurred. And they're saying that it was the wife who did it. The wife is saying, no, I dropped him off at the party, and when he was missing, I finally went and found him on the lawn the next morning. And the state is saying that she hit him, backed him into him with the SUV. There are crucial pieces of evidence that seem to be missing. There's a lot here. There's a lot going on to this story that the defense is saying this is a cover-up. This is a cover-up. They're trying to pin this on his wife and she's saying, I had nothing to do with it. This is something that happened in the house at the party where she was not invited or was not present for. A lot going on. So, somebody's not telling the whole truth, but the injuries he sustained, to my eye and to the defense's eyes, looks more like a dog attack than a car incident. The bites and scratch marks, they do look like bite and scratch marks to me. I don't know how a car causes those on your arm like that. But, yeah, so we'll go into all that. Let's see. We have a couple things to shout out as well. Not today. Satan just gifted a membership. Let's see who else. Selena Key Armitage gifted a membership as well. I think you did one earlier as well. Am I mistaken, Selena? I think you. I thought you gifted one earlier. But thank you very much. Good to have you here, Amanda, and congratulations also on your sobriety. That is awesome. Amanda Cunningham, thanks for the great comment while I decorate cookies. I need to send some RA themed cookies to include SMB pickles soon. Panda Cakes Cakery sounds awesome. Kay Scarpetta gifted 5 memberships. What a way to kick off the morning. You guys are amazing. Thank you so much. Some people who have accidentally found themselves being gray look like they're now going to be green. Thanks to you guys. Let's see who we have. Casey Jones is one of those. Hippie Chick is now green as well. Welcome to membership. And let's see the last 5. Allie B, Wayne Hatchell, Catatonic, Judy, you're back in green, and Carol Williams, all in green now, thanks to Casey Scarpetta. Those are the last 5. So thank you all. It's good to be here. There was a hearing yesterday from what Court TV has on YouTube. Yes, Britta, that I know you're one of the ones who's really interested in this Karen case. I am as well. Karen Reed, I should say. If you nowadays when you just say Karen on the internet, people think that you're talking about a derogatory term, which I'm not a big fan of. I'm not a big fan of using somebody's name as a derogatory term. Anyway, at the same time, I'm probably guilty of doing that in various situations. So I'll try to do better. Rudy Patuti gifted a membership as well. Thank you, my friend. A good pat and a dog bone for you. Lindsay Bay, member for 1 month. I learned so much from your channel. Thank you, and thanks, chat. Lindsay, chat here is amazing. This community is wonderful. Thank you for being part of it. It would not be the same without you. That's for sure. Okay. Good morning, says Austin, listening from Illinois. Is Arkansas Magnet Fisher in the house? Did we see? Is he and his better half with us? Just checking chat. I'm not seeing yet. I'll have to get with Arkansas Magnet Fisher and see if we can use him to help us get access to some Arkansas police video that apparently the state only thinks Arkansasians. What is it called when you're from Arkansas? An Arkansasian? Arkansan? What's the term? I'm a North Carolinian right now because I live in North Carolina. But if I were from Arkansas, what's the term that would describe me other than just resident of Arkansas? Arkansonian? Arkansans. There you go. Arkansas Magna Fisher is in the house as well. I'll have to talk to you, my friend, to see if we can find a way to use your residence, if you still live in Arkansas, to Arkansans, just sans on the end, to find access to some of the police footage, which they tend to only release to residents of the state. So I don't know. We'll talk about that another time. Judy says, I'm a Hoosier now. An Arky. We can shorten it, Adriel. I think that's pretty good. Arkanstonian. I don't know. There's a lot of different ways. It's a tough one. I don't know which way to go with that. Arkansite. Anyway, we're neither here nor there. Let's get just call it a Razorback, says Judy. Go for the team they cheer for. That's an easier way to differentiate somebody. I will show you that I'm in a T-shirt today. Not just any T-shirt. I'm in a very specific T-shirt. This one says everything. Well, let me clear this off so you can see it. It says everything I know about law I learned from Matthew Harris Law. I'm wearing this in honor of Matthew Harris's new video drop that should happen today at noon. I'm excited about that. Matthew Harris helped me out a little bit yesterday with a legal question I had, as well as Nicole Goodman Law. It's nice. Oops, that's not what I wanted. Let's go back right here. It's nice to have friends with a lot of knowledge when it comes to legal issues. They're fantastic. So thank you very much to both of them. Just not legal advice, but just friendly advice. So, all right. Where are we at? Where did I missed roll call. We can do a roll call starting right now. If you just one time in chat, raise your hands. Raise your hand if you'd like to be included in the roll call. I'll try to call you off. We have a smaller group today than we've had during some of the bigger trials, and that's good. I like this. I like the community nice and small. Here we go. Ready? TA, welcome. Be kind. Abby UK's in the house. Alicia C, hello. Leonard Amber. Nicole Goodman Esquire is here. Tipsy Tracy. Sharon McDonald, welcome. Internet owner today. Red Pen. Jackie P, 1954. Weebug. Sharon Jen D. Verity with stars. Verity with stars is in the house. Jacofori. Alex S. Sorry, I want to put an I in there and make it Alexis. But Alex S. Ashley R. Dawn Spooky Days. Hello, welcome. Oh, it's going so fast. You guys are so fast at this. Pat Hansen, Mayla's mom, Lindy, Amanda Hagerman, welcome. Britta Aller, good morning. Andriel Hillis, every time, Andriel. Rosie Tulips, April Cantrell, Judy says, I'm good. Sandy Rescon, Dizzy, Irish Bella, hello. Sarah Mack is here. Carrie Brooke says, everyone tell your cats I said, pss, 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 pss. What, you know how to call
everyone tell your cats I said, PSS, 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 cat face.
Okay. You know how you call a cat? You open the bag of cat treats. That is the international sound. It works for cats all over the world. You open the bag of cat treats, and that's how they come. I'm here every day for months, says Carol O'Neill. Thank you so much. Carol Jarrell also here, right next to you. 2 Carols in a row. Elizabeth Pulowski, welcome. Whitney Bravel, Lost Souls Paranormal, shout out to the love of my life. Danny, are you here? Danny, come in, Danny. Lydia Vaz, welcome. Lacey Sturg, hello. Macy Combs, Clipsons, Vixen, that's Amber. Welcome, Amber. Good to have you here. Loved chatting with you yesterday on the text. Keep Guessing is here with 3 jars of pickles. Thank you very much, Keep Guessing. Des is here. Kim Jeffrey, Amy McGee, Katrina, Melissa Montez, Erica 843, Tracy Anzar, Grit Grinder, hello my friend, Rosie, Morton Anderson, good to have you here. The Brown Barn, welcome, Kevin. Britta Aller, looking forward to that case. Seriously, Britta, keep us in the know on that one. I know you've got your ear to the ground when it comes to the Karen Reed case. I would love to follow that one. I might have to see what I can do. It's a bit. I think timing-wise, it presents some challenges because I think it's starting to happen into the July timeframe, if I remember right, and we have other big things with Sarah Boone happening at that time, and so we'll see what we can do. It's all just time and money, which apparently we don't have enough of either, so we'll try to make things work. Carlisle, welcome. Four Sons Mom, hello. JREPTX is in the house. Misty Bricker, hello to you as well. Purple Butterfly 77, welcome. Marcy C, Shelby Allen, Baby Bear is here. Hello, Baby Bear. Thank you for the treats, by the way. I've finished all of the all that you sent me, and it was wonderful. I think I'm gonna order some. Austin Midaw, welcome. Lynn Hoke, Scott I is here. Morning. Nicole N, hey.
Stole it as well.
Alex stole it. Gabby Gabbs is here. KR, Grace Sanchez, Ashley, Casey Jones. My kid's personal Uber driver. How is it with one that's getting old enough to drive themselves and move on in life? It's a rough time. I'm commiserating with you. Bushman 613 is here. Velda Lynn, Melissa Montes, Lizzie Dog, Buzz Nevermore. Angie says I'm back. Boxer Mom is here. Have an easy day. Anyone know what people from Idaho are called? Idahoans. That's what I'm sticking with. Kay Patterson, welcome. Rev Minister is here. I just scrolled so fast. I'm catching up. Michael Lacerte, Shells, Bryce Peedy. Please don't stop the music. That's a good song. Angie, Sue Schneider, welcome. GSD Mom, Britta Aller, Jackie Hughes, Kristen Kingsbury, Lee, Josh Frick, Julie Martin. Let's see. Tyne Van Egmond, welcome. Hockey Mom 223 is here. Grandma Nancy, T. Marie, Annette Louise, good morning to you. Stacy with the butterflies. Annie L, hi all to you. Keep Guessing. I think we got you earlier. Tony Schaefer, Rudy Patootie, Brittany Turner. We finally caught up to Carrie Brooks' comment about the cats. See, I'm catching up. Elizabeth Sanchez, Courtney, also with the butterfly. MT, glad to find you all. Good to have you here, MT. It's a wonderful group. Morton Anderson, Goodman Law Firm says, happy Friday, Scott. It's Thursday. It's Thursday. I hate to ruin your day, Nicole, but is it your Friday? Is that what you're saying? Because I'm pretty sure pretty sure you
I'm
got
not a
one more
cat.
day. One more day of work, unfortunately. Greg McNeely, Arkansans or Arkansasers? Arkansasers. That's a good one. I like that. Share Bear is here. Twubble. Hello. Ruth Whaley. Good morning, True Crime Nerds. Julie F. DSN. Ritz. Spooky Days. Al is here. Welcome. Lego My Briefs. Good morning to you. Let's see. Angie. Vicky Potts. Sasser Girl 69. Blair Teague. Carol C. Mary DeConing, Jackie Ferrara, taking a seat. Sorry, I just called you out there. Ritz, Tori the Seed Lady, Julie F. Okay, did you find the bug from yesterday? This is where we need to stop right here. Rosie, yes, I did. I found it this morning.
I was kicked back, taking it easy.
I was thinking, there's no way I'm going to. I know it's in here somewhere, okay? Because I mean, there's no really way to get in or out of this room other than the door, and I kept it closed. And so we're looking all over the place, and I found it way up high on the ceiling this morning. And so I'm thinking, I can spray this bug. Okay, I can spray this bug, and I know what it will do, because when you spray the bug, it starts to fall. And when it starts to fall, it thinks, I'm falling, and it spreads out its wings, and it starts flying. And what these bugs do, what these bugs do when they start falling is immediately they look for the closest warm body to fly at. I don't know how they do it, but they immediately, it's like you've now sprayed them with poison, and now they're dive bombing you. Luckily, it fell on its own, because we do treat the outside of the house for bugs to make sure bugs don't get in. And so it was like not doing well. It was walking slowly already. So it was giving a poor go of climbing the wall to begin with. And so it fell on its own. It landed on the back of my TV, right on that one right there. And I said, I will buy a new TV if I have to, but I'm going to spray this bug. And if it shorts out the TV, that's fine. So I sprayed the bug on the back, killed it, and it was all good. And then my youngest little RA scooped it up and put it in the garbage in a little dustbin. Okay, that's where we are on that one. But thank you for asking. Judy says, thank you for the membership. Good to have you in green again, Judy. That's awesome. Julie F., member for 1 month. Good to see that courthouse color change by your name. Let's see. We'll run the can opener. Yep. D-Nice, hello. Amy McGee. Did she just spell Mississippi? Almost. PSSS, PPSESS, SPPS, PPI. I think that's it. Yes, Merritt was found guilty on all counts, Jack O'Forey. I saw that the other day. That was, I think most people agree with that verdict. Let's put it that way. Wayne Hatchell's here. Welcome. Let's see. KH in South Carolina. Lisa, meaning banana. Hello. Smoke Sky. Ritz has a cat face. Welcome. Laura 77. Jackie Hughes, to the gift givers. You're so kind. Kevin is here. Let's see, just finishing up roll call here, and we'll get all caught up. Julie F. Nanageek Joe Ellen, welcome. Adrielle says,
cheers, y'all. Have a wonderful day. Call me hand gesture with light skin tone. Hands with light skin tone pressed together. Red heart flexed bicep with light skin tone saluting face.
That was from Ivan. We'll pull that up in just a minute. Thank you very much, Ivan, for that. Adriella says, it's all good. Most people call me Ann. In fact, most people I know thinks Ann is my actual name. My wife also shortens her name, and I very rarely, if ever, have called her by her full name. Sharon McDonald says, have a birthday today. It's Tori the Sea Lady. Birthday. We have a birthday. That's awesome. Is there anyone else who shares a birthday with Tori the Seed Lady today? Wendy Bermridge, welcome. NBR1. Grandma, welcome. I'm here. Turn on can opener. City of Molina, welcome. Pam D. Okay, happy birthday to you. It's Tori the Sea Lady, right? Happy birthday to you. Happy birthday, Tori the Seed Lady. What's the timing? Happy birthday to you. That was a long name to fit in there. But Tori, happy birthday. Hope you have a fantastic one. I'm glad you can spend a little bit here with us. Marcy C is in the house as well. Bradley McKay is here, but lurking. Carrie Brooke is here. Van, good morning. You're early, I think. Back at you, says my cat. Pow. Blair. Mike drop. Arkansas Magnifisher says, I recovered a .38 special handgun in the Little Red River yesterday, and the police came and retrieved the gun. Doing magnet fishing is what he's talking about, obviously, as the name suggests. That is awesome. That is awesome. A .38 special is a revolver, for those who are not familiar with handguns. It's going to be a... Is it going to be a 5-shot? A .38 special? A 5-shot revolver? and finding one in the river, it generally means that it was put there by somebody who probably did not want it found. So the odds of having the firearm you find in the river be involved in a crime are very high. It's actually very difficult to link the gun unless they know the serial number from a theft or something like that to the crime, because the water just does a number on them. But that's cool. I hope you got some pictures, Arkansas Magnet Fisher, and I also hope that if your state allows it, that if nobody claims it or it's not stolen or used in a crime, that you get it back. Some states have that little thing, that little caveat in the system for you. Brandy Churchwell says, wanted to pop in and hit the like button. I'll be on Replay Clue tonight to catch up. Brandy, have a wonderful stream. I think you're following the football trial. Is that right? I forget which one you're following today. You've been tweeting all morning, and I've been really busy trying not to get distracted. So I've had the blinders on when it comes to Twitter. I'm like, I know she's talking. I know if I start reading it, I'm going to fall down a rabbit hole, and I'll be on Twitter until like 30 seconds before I'm supposed to go live. Brandy, thank you so much. Appreciate you being here. Also gifted a membership. You're amazing, Brandy. You don't need to do that. You're wonderful. Have a fantastic stream. I hope it goes well for you. See, Elizabeth Sanchez is here. Welcome. Greetings to all the cats in the world, says Ritz. Maggie Carr, good morning to you. Mom to an Angel is here. Welcome. Black cats are the best, says Jen, just stating some fact. Radioactive. How do I know if I've made my 1 month yet? I don't remember when I joined. Oh, Patrizia Ferrara. I mess up your name. Patricia? Is it Patricia? Patrizia Ferrara. The courthouse by your name is light blue, which is the indicator that you have been a member for more than a month. Carrie Brooke is on the first membership here, the first month. Her courthouse is dark blue. When it goes light blue, that's going to be the second month. The third month, it's going to turn a light green. And then it does slow down a little bit. The next color after light green is going to be yellow. And we have a couple people that are very close, probably within a month of turning yellow, as the channel itself is fairly young. Bug Dugger, welcome. Good to have you here. Good morning, Lily, 2006. Hello, please don't stop the music. Goodman Lusser, glad to help yesterday. Hope I didn't text the burner too late, but I had to share the burn after reading letter release. We're going to talk about that this morning. Thank you very much, Nicole, for doing that. Now I'm jealous of Matthew and have to come up with my own tea. You'll need a different day because this is the Thursday tea. I have to wear this one on Thursdays. But yeah, something of the similar theme would be awesome.
I'm not a camel.
Green is my goal, says Carol O'Neill. That's wonderful. Tomorrow would be J.J. Velo's 11th birthday. Happy birthday, J.J. Thank you, Leonard Amber, for that. Just putting things in perspective there. When's her sentencing? Is her sentencing in July? I think Lori's sentencing is like July 26th or something. Everything's happening right at the same time that Sarah Boone's trial is happening. It's like everyone's court calendar that has nothing of interest. Okay, it's all these little cases and people, pleading guilty to lesser charges and whatever. And then in July, it's like boom. Here's where we have all the good stuff. It's gonna be crazy. Okay, let's see. Burner phone, just burner would work. ! Burner. Would get you that number there, Arkansas Magnet Fisher. Hopefully we get some revolver in the river is usually not a good sign. I'm looking for Ivan's message, which I somehow missed. There it is. Ivan says, cheers, y'all. Have a wonderful day. Love the flecked bicep. It looks like a smaller version of your own, Ivan. I'm not sure if they had like the actual size bicep one that you could use for an emoji, but looks great. Thank you so much, my friend. I will stalk that pest until it's gone. The bug watch is over. It's over, and I am so happy. It's good. I just learned of the giant water bug today, 5 inches on average, and carries eggs on their back. What, Eddie, why do you need to bring that into our chat? Why do you have to bring that up? Oh, my goodness, 5 inches? Okay, since you brought it up, this is Eddie's fault. It's your fault that I'm telling this story. Just, Eddie, so you know, it's entirely on you. If people unsubscribe because I tell this horrific bug story, it's your fault. Growing up in the Intermountain West, my bedroom was in the basement. I was probably a teenager, which means that I probably in my life never made my bed once. That's how it goes. Okay, the blanket sort of goes on the bed or close to the bed. You get up, you throw it off. If you make the bed, You just have to unmake the bed to climb in. This is my reasoning, right? So growing up, I did not make my bed very much. I probably did when my parents gave me some encouragement to do that. But imagine this. I'm in my room. There may be a few items that I regularly use that are on the floor here and there in an orderly pile in different areas around the room. So it wasn't the cleanest bedroom is what I'm saying. Okay. And so it's I don't know, late summer, and spiders are a thing there. There are some spiders. Usually they're small. Usually they're not much problem. Little tiny ones. Occasionally they'll bite and leave a little like a mosquito mark thing or something during the night. But I've got my bedspread and it's cold. I jump into bed, grab the bedspread, and to grab it I have to like sit up and grab it to pull it up over me. And as I take it and pull it up over me, the bedspread comes up over the edge of the bed, and on the bedspread as it comes up and over is a wolf spider of gigantuan proportions. It was huge. A huge wolf spider just like clinging to the thing as it comes up, and its abdomen, its butt end was covered, like crawling with little babies. It was like carrying an army of little baby spiders, okay, tiny ones, and so many that it was like seething with little spiders that were like moving around. It looks like a tarantula. It was, you guys are not getting the actual, it was like this big, okay? It was huge. It was huge. So I pull it up. Now my first impression, okay, which probably was not the right one. This is the wolf spider. It was not a tarantula. My first impression was, happy the day deserves us, burn the house down. Yes. No, it was not. It was like, So I throw the blanket off and the spider goes flying, and the little baby spiders go everywhere. It's like a cloud of spiders just poof. I ran out of the room looking for a shoe because my shoes were not in my room. They were wherever else in the house. I had discarded them. I came back in and I found some of the baby spiders. But I never found the mama. I never found the mama. I have no idea where it went. And I moved out shortly thereafter. No, just kidding. I didn't. It just never turned up. It never turned up. And I'm sorry for telling that story, but you know whose fault it is, right? You know whose fault it is for me telling that story. A 5-inch water bug is a no-no, Eddie. It's just I can't do that. Anyway, somebody just said, I just scrolled through and it said my third, oh, there it is, Share Bear, my third grand baby will arrive tonight. That is awesome. Share Bear, congratulations in advance. Hope everything goes well for the baby and mama. Congratulations to you as well. All right. That was my Uncle Fred you killed, says Bug Dugger. Yeah. Good times all around. All right. So now, yeah, the viewer numbers, I wish I could show you the chart. It just went like this. Like, nope, spider story. I'm out. So, anyway, we are covering a couple things today. Let's get right underway because we've delayed things long enough, but I need to start the AC because I can already tell it's going to be a warm one today. I'm not sure what weather is in store for you wherever you live, but it's a little toasty. And Mrs. Ori has actually got the wee ones out of the house, so the door should not be beeping. If the door beeps, the door opens and closes, it's because there's an intruder. So I may have to get up and run if that happens, and hide or whatever. I'll take the gavel with me, but that's it. Okay, what we're going to start with first is we're going to start with the laundry letter, if that's all right. The first thing, we heard the laundry letter came in yesterday in the hearing. The prosecution was they had a order to suppress or a protective order they wanted to put in, basically, and we'd like to protect this document so we don't have to give it to the defense because it's embarrassing for my client and it makes us look bad. They had a much more eloquent way of putting it. They spoke for a couple hours about it all together with all the other motions, and basically it was just like we just really don't want him to have this because it really hurts our case, is what it is. So let's take a look at this. Let me make sure I got this right. I think I can make it a little bigger. No, I can't. Oh, yeah, I can. There we go. Here we go. So let's switch to this one right here. Okay, we are going to read this letter really quickly together. This is a typed version of the handwritten letter. Now, what you need to know first, Tabitha, good to have a courthouse by your name. M80, welcome. Good to have you a member. Thank you. Welcome to the gallery. What you need to remember about this letter, on the outside of the letter, it says basically to Brian Laundrie or something like that. Brian Laundrie, burn after reading is what it says on the outside. Then you open it up, and this is what we have. It says, from his mom, Roberta Laundrie, to Brian. It says, I just want you to remember I will always love you, and know you will always love me. You are my boy. Nothing can make me stop loving you. Nothing can or ever will divide us, no matter what we do or where we go or what we say. We will always love each other. If you're in jail, I will bake a cake and put a file in it to like saw through the bars. Or maybe that's the shiv. If you need to dispose of a body, these are your first go-to. If you're in jail or if you need to dispose of a body, she says, if you need to dispose of a body, I will show up with a shovel and garbage bags, she said. If you fly to the moon, I'll be watching the skies for your reentry. If you say you hate my guts, I'll get new guts. Remember that love is a verb, not a noun. It's not a thing. It's not words. It's actions. Watch people's actions to know if they love you, not their words. Therefore, I am certain that neither death, nor life, nor angels, nor the ruling spirits, nor the things present, nor things to come, nor powers from above, nor powers from below, nothing entire created world can separate our love, neither hostile powers nor messengers of or heaven or nor monarchs of earth. Nothing has the power to separate us. This is from Romans 8:38. She's quoting the Bible to say, I'll help you bury the body, and no one's going to know. No one's going to separate us. If nothing can separate us, hatred, not hunger, not homelessness, not threats, not backstabbing, not even sin, not the unthinkable or thinkable can get between us, she added. Not time, not miles and miles and miles. Not even the 2,000 miles between us and her body. So this is the letter that for some reason the prosecution thought maybe it might not be a good idea if the defense sees this and is able to reference this in their discovery. Okay, now out of context, maybe. That what we have to do, we have to look at this. It does look a little strange. Okay, so let's step back just a tiny bit, and let's say we're going to take a look and ask her, like through the filings that we've had in the court system, we're going to ask her what this meant or what she meant by it. So let's bring over right over here. Let's bring over the affidavit. We'll bring over the affidavit of Roberta Laundrie in support of motion for protective order. So this is what she filed, I think it was early in March, if I check the date, regarding that letter saying, hey, we should not have to release it, and this is why. Okay. When was the letter sent? This is the big question. When was the letter sent? It was not dated. And this letter will address this a little bit, Kim, address that issue a little bit. Okay. So here's what goes. So I need to make this full screen so I can see. Okay. And ignore the BS meter on the right-hand side of the page. That's somebody else's tweet that was tweeted in response. That's not mine. This is through Brian Enton on Twitter. He posted the links to this, so I appreciate him doing that. Affidavit of Roberta Laundrie in support of motion for protective order. State of Florida, County of Sarasota. I, Roberta Laundrie, am a defendant in the above-styled cause and do hereby swear and affirm that I fully understand the meaning of all the terms of this affidavit. I wrote the letter requested by plaintiff's second request for production. I wrote the letter to my son, Brian Laundrie, on or about the end of May 2021. Although I do not know the exact date I wrote the letter, I do know that I wrote it and gave it to Brian before Brian and Gabby left Florida for New York, which was on June 2nd, 2021. Brian and Gabby went from Florida to New York before they went out west. The purpose of the letter was to reach out to Brian while he and I were experiencing a difficult period in our relationship. Brian and I always had a very open and communicative relationship, and in the months prior to the trip, our relationship had become strained. Brian and I shared a love of stories, and some of the language in the letter was using similar phrases to describe the depths of a mother's love. The two books that come to mind are The Runaway Bunny and Little Bear. In addition, Gabby had given Brian a book called Burn After Writing, which contains printed questions to which the reader responds by writing their answers on the page. The back of the book instructs the reader to create a secret book and then destroy by burn after writing. The bottom of the back cover says, write, burn, repeat. Brian, Gabby, and I often joked about this book and the importance of being able to express yourself. If you were embarrassed or simply did not want anyone to know your thoughts or feelings, then the book offered the perfect solution by telling you to burn it. This is where my message to Brian came from, and one I wrote on the cover of the letter for Brian to burn after reading. In short, I was trying to connect with Brian and repair a relationship as he was planning to leave home. And I had hoped this letter would remind him of how much I loved him. There were some other phrases that I used in the letter which are not found in the books I shared with Brian as a child. However, these phrases were common enough in our circle of friends and family to describe who you could turn to in the most troubling times of your life. While I used the words that seem to have a connection with Brian's actions and his taking of Gabby's life, I never would have fathomed the events that unfolded months later between Brian and Gabby would reflect the words in my letter. The words in the letter could never have been a comment on that tragic situation as they were written so many months before. My words to Brian were meant to convey my love and support for my son through a light-hearted and quirky reminder that my love for him was not diminished and could not be shaken by the miles of separation we would soon be faced with. Although a few of the words in the letter are being quoted by others as having a connection to this case, all of the words taken together and in the context of the reason of the letter was written show that there is no connection. In addition, there has been some speculation that this letter was in Brian's possession or in his backpack when he died, insinuating that I gave it to him as he left my home on September 13th, 2021. But that is not true because the FBI had the letter in their possession and questioned members of my family about it prior to October 20th, 2021, when my husband and I found Brian's remains in the reserve. I repeat that the letter I wrote to Brian before he left with Gabby for their fateful trip was nothing more than a private communication between myself and my son, and I never expected anyone else would read it. In some way, I did not want anyone else to read it, as I know it is not the type of letter a mother writes to her adult son, and I did not want to embarrass Brian. That is why I wrote "burn after reading" on the envelope, and I knew that Brian would know what that meant. I am now appreciative that he actually kept it. Signed, Roberta Laundrie, and it's notarized. So that's the response. Yes, we are going to stream a trial here today, Emily, for sure. We're getting over to the Family Feud trial, which has dropped 3 new videos in the series. They're just a little delayed, so we'll be picking that up here in just a minute. I just want to finish with this. There's one more I want to show you. This is, I believe, also through Brian Anton, who has shared this additional posting that is from Roberta Laundrie, is who he says. The letter to Brian, this is a new one since the hearing. Basically, this is yesterday's announcement. The letter to Brian was written prior to Gabby and Brian leaving my home for their trip. Previously, I submitted an affidavit to the court for very limited purposes, but that is not the whole story. Now that the letter has been shared, I ask that you read it in its entirety and understand that the letter contains other phrases besides those highlighted by Pat Riley for sensationalism and to bolster his case. I truly loved my son and simply wanted to convey to him how much he meant to me and how much I loved him. I am sure people use phrases all the time to express to their loved ones the depths of their love. Although I chose words that I thought would be impactful with Brian given our relationship, the letter was in no way related to Gabby. Please read the entire letter before you believe the hype put out by Pat Riley. So that is the update on that. Interesting. The burn after. Is there any proof it was written prior? That will be a very hard one to prove. A couple people would know. Brian Laundrie would know. He ended his own life. Roberta Laundrie would know. She says that it was written prior. The FBI may have some evidence somehow, but it's very difficult to prove. I don't know how they would do that. I'm thinking they would have to have like a notebook that has impressions on it that were dated, and a page matching a page tearing out of a book that has dated pages before and after. It would be very difficult, and it's not very likely that they would. So we'll see. But anyway, that's the substance that we listened for the hearing yesterday. So yes, there is room for everyone on the front row. Irene, welcome. Please take a seat. Burying a body is something left for a best friend to help with, not a mom. No winners in this case. I'm confused with it. Laura, it is. Both families have lost a child. Both one. There's no one to put in prison. There's no one to go to jail for for the murder. I don't think we'll ever know a full picture of what happened. We have an account from Brian from the last letter he left about how events took place and why he took her life. But it's crazy. It's a rough one. Okay, but that being said, we want to shift gears. We have the afternoon video of the from the 23rd, so we're 2 days behind, and we also have all of yesterday's video. So basically, we have everything but what they're filming right now in the trial, and they've also been condensed. The video we have to go over this morning is about 2 hours long, and it covers everything that happened all afternoon in the Family Feud trial. They're doing a better job. We're getting more video. The interview. I haven't watched all of it together, but I've skipped around in there. It looks like we get to see some witnesses. We get to see some evidence. We get to see the table, both defense and prosecution table, and it's going to be good. Selena K. Armitage gifted 5 memberships. Thank you so much, Selena. I appreciate you. That is huge. Thank you. The file in the cake was an expression. She couldn't actually do it. Yeah, it would be caught in a metal detector, and they don't allow you to just mail cakes to inmates. I'm looking at the burner phone because Arkansas Magnet Fisher sent me a picture of the 38. Ooh, woot. Okay, we're going to share this. I would say this is probably 10 plus years old as far as how long it's been in the water. That's just my guess. But give me a second. We'll see if we can pull this up on the screen and share it with y'all. Show and Finder. Let's bring it. I'm going to replace the woodpecker image. Okay, B2. This is the Arkansas Magnet Fisher found this while magnet fishing in was it the Red River or the Little Red River? I forget. But this is the holy grail of what you want to find when you're magnet fishing. You always want to find the firearm. That and a safe. Between the safe and the firearm, that's what you go for. Unfortunately, you find like stolen bikes and bike parts and car parts that have been dumped, and lots of construction equipment and tools, and just various and sundry shopping carts, things that are very hard to lift up with and very hard to get rid of. But that's been in there a little while. I'm not sure if they're going to be able to actually make anything out of it. So I wonder if were you able to tell if it was loaded? Just curious. Yeah, it's a bit weathered. That'll probably buff out though. That'll probably be okay. So yeah, it's gonna be a tough one to trace on that one. Thank you, Arkansas Magnet Fisher, for sharing that picture with us. Looks amazing. That makes me want to go out and do some magnet fishing. That's what it does. Okay, let's cut over here to the case we're following. Let me make sure we have everything ready. I think we do. And to switch my layout. Hang on one second. I'm struggling with my sources are not where they need to be.
I was kicked back, taking it easy.
Is 1. Box 2 is going to be 6. Almost there. Just one more second.
Bring the jury.
Bring the jury. We're ready for some trial footage. Okay, here we go. Let's bring this up. And turn this one off. And yeah. It's not quite where I wanted it. I'm going to be down here in the corner. Here we go.
We are back on the record in open court. The jury is ready to come in. Mr. Jones, anything before the jury comes in?
Witnesses back there.
Yes. Yes, Your Honor. Nothing else, Your Honor. People are ready.
All right. Ms. Schnock.
Ready.
All right. Let's bring in the jury.
comes the jury. The camera pans up to the ceiling while the jury's coming in, just so we don't accidentally show anybody. I'm going to try to make myself just a little bit smaller here. How can I do that? There we go. That'll work. Is that all right for you guys? If I stand right here, make it a little more centered. The feng shui is not off. Yes, they're trying to fix it. It's been a problem. They're dropping videos a little faster now. Let me get the audio a little tuned up. There's still some audio issues as the microphones are placed around the courtroom in a funny place. So sometimes you'll get audio on the left channel, sometimes just in the right. But get this. This is the very speedy trial. Murder happened this year in February. Thank you, bailiff.
Good afternoon, ladies and gentlemen of the jury. We are continuing with the people's case in chief, and they will present additional evidence today. Mr. Jones, you have a witness?
I do. Your Honor, the people would call Mr. Taylor Hyman.
Bailiff's just wandering around the courtroom. Maybe the bailiff's going to swear him in.
Sir, if you'll step up to the front of the courtroom.
Judge might need glasses.
And if you will raise your right hand and then be sworn by the clerk.
You do solemnly swear that the testimony may give in a cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. All right, and if you come around here and have a seat right here in this chair, and then kind of scoot up to the table to where you're comfortable, bend that microphone up so it's in front of you, and then please speak towards the microphone. You may inquire, Mr. Jones.
Can you tell me your name?
Taylor Hyman.
How do you spell your last name?
H-E-I-M-A-N-N.
Mr. Hyman, where do you live currently?
2510 Kentucky Road.
Do you have a neighbor directly to the east?
Yes.
And who lived in that residence?
Becky Bliefnick.
I'm sorry, you say Becky Bliefnick?
Yeah.
How long have you lived at your current house?
A little over 2 years now.
Who do you live there with?
My wife, who is also named Taylor Hyman.
Your wife's name Taylor Hyman too?
Yeah.
Taylor and Taylor.
Okay.
Very confusing.
If I could approach you.
You may.
I'm going to show you what's been marked as People's Exhibit number 9. And I'm going to ask you, do you recognize that?
Yes.
Can you tell me what that is?
The picture over satellite image of my house and Becky's house.
Your Honor, I'd ask that People's Exhibit 9 be admitted into evidence and published to the jury.
Any objections?
No, Your Honor.
Court will admit Exhibit 9 into evidence, and it may be published to the jury.
And for the record, we have People's Exhibit number 9 on the screen now. Mr. Hyman, there are two houses on this picture. Which one is your house?
The one on the left.
And there's a driveway that's headed north and south on that. Is that your driveway?
Correct.
Do you have any type of cameras or video recording on your house?
We do.
Can you tell me about that?
They're located near the truck there, probably right at that corner there, pointed towards the road, towards up the driveway to the road. Yeah.
Tell you what, I got a little laser pointer here.
Lasers.
You point that laser pointer where your
We get to
camera
see the
is.
laser.
Right there.
Green laser. It's a little hard to see, but it was the one on the left. Got a camera in the corner right there on the property by the driveway where the truck is, the red truck.
I want to talk to you now about February 14th, 2023. Did you have those cameras on your house at that location on February 14th, 2023?
Yes.
Tell me about how those cameras work. Do they go to a computer? Do they go to a phone? How do those videos work?
So they detect motion. Once they detect motion, they will notify my wife and I's phones to where we can see the video.
And if they detect motion, do they record at that point?
Yes, they record we have it set at 7 seconds.
So they don't record all night or all day. They record for a specific time.
Mm-hmm.
And I'm sorry, I got to say.
Yes, they do. If they detect motion, they go.
You also told us that they have a sensitivity setting.
Yes.
So what does that mean?
So if we put all this, I believe it goes from a 12 to 0 on sensitivity. If you put it up to 12, it'll catch stuff on the road, people driving by and stuff like that. We had it set at a 7, I believe. So then it doesn't detect the people on the road, just to save battery life and stuff like that.
On
Pool video means
February 14th,
there's one cameraman and he provides the video for all the interested parties.
Did you get an alert on your phone that there was motion in your driveway?
Yes.
And did you view that video?
Yes.
When you viewed that video, did you see a person walking in your driveway?
Yes, I did.
Did you know who that person was?
No.
I want to be fair. Can you tell anything about that person on the video? Can you tell how tall they are?
No.
Can you tell what race they are?
No.
Can you tell if they're a man or a woman?
No.
I'm going to hand you what's been marked as People Exhibit 10. Can you tell me what that is?
That is a screenshot of my phone whenever the recording took place. Has a date and time on it. See that there's also my wife's car in the driveway there.
Now, on that date and time, is that the date and time that the video is recorded?
Yes.
And there are actually multiple dates and times on there, is that right?
Correct.
So you had to highlight one on your phone to play that particular video.
Yes.
And the video in People's Exhibit 11 that I'm showing you, that's from February 14th, 2023, at what time?
12:37.
Your Honor, I'd ask that People's Exhibit number 10 be introduced into evidence and published to the jury.
Just a second.
Judge is reviewing it.
No, Your Honor.
All right. Exhibit 10 will be admitted, and you may publish that.
It's a screenshot.
So the video we're talking about is this video here, 12/14/23 at 12:37.
It's 2/14, yes.
Oh.
I believe you said 12 on accident, but yeah.
I did. You're right. 2/14/23 at 12:37 a.m. And again, for the record, I'm handing you People's Exhibit 11. Is that video?
Yes.
The video is working correctly?
Yes.
The time and date on the video is correct?
Mm-hmm. Yes.
And you know that because of other times that you've watched the video and recognize that the time is correct?
Yes.
Your Honor, we'd ask that People's Exhibit 11, the video from 2/14/23 at 12:37 a.m. be published to the jury.
The video be admitted and published.
Sorry, admitted and published.
Ms. Schnock, any objection?
No.
They probably will not
11
play
will
the
be
Family Feud
admitted
video.
and published to the jury.
This should take about a week, but we're a day behind because of the way the court releases the video. They don't let us play it live. But you can barely see any movement on the left side of the screen.
Now I want to move forward then to February 22nd, 2023. On February 22nd, 2023, did you also get 2 alerts on your phone about motion in your driveway?
Yes.
And did you watch both those videos as well?
Yes.
And on both those videos, what do you observe?
A person coming down our driveway and then a person going back up the driveway, similar to that video right there.
The first video was on February 22nd, 2023 at 1:05 a.m. Is that right?
Correct.
And the second video was February 22nd at 1:53 a.m., is that right?
Yes.
Now, in between, there was another video at 1:48, is that right?
Yes.
Can you tell me about that video? Did you view it as well?
Yes, and there was a possum or raccoon going up and down the driveway as well.
You don't see any person on that video?
No, I did not.
And that same day at 2:17 a.m., there was another video on your phone as well, is that right?
Yes.
Can you tell me about that video?
Yes, my dog woke me up and had to go to the bathroom probably, so I took her out. And we saw the videos, so I went out there, checked the garage, assumed someone was checking the garage looking for cars, like always happens in Quincy, but so I checked, nothing seemed to be out of place, taken or out of place, so.
Your Honor, if I could approach the witness. You may. I'm going to hand you what's been marked as People's Exhibit 12 and People's 14. Are those screenshots like what we just saw, People's 10?
Yes, sir.
And shows the dates and times of those particular videos?
Yep.
And I'm going to hand you People's 13 and 15. And are those the CDs of the videos that we just saw in these screenshots?
Yep.
Your Honor, I'd ask that People's Exhibits 12, 13, 14, and 15 be admitted into evidence and would ask leave of court to publish them to the jury.
Any objection to People's Exhibit number 12?
No.
Any objection to People's Exhibit number 13?
No.
Any objection to People's Exhibit number 14?
No.
Objection to People's Exhibit number 15?
No.
They will all be admitted, and you may publish them to the jury.
That was the first one we watched, the guy walking behind the car.
Now on the screen is People's Exhibit 12, and Mr. Hyman, we're looking at a video. It says Wednesday, but that was Wednesday the 22nd at 1:05 a.m. Is that right?
Yes.
And People's Exhibit 13. And the next video, this is People's Exhibit 14 on the screen right now. We're looking at a video from Wednesday at 1:53 a.m. Is that right?
Yes.
It's just somebody walking on the screen. You can't make anything heads or tails out of it.
Your Honor, if I could approach the witness one more time.
You may.
I'm going to hand you what's been marked as People's Exhibit 16. Do you recognize that, sir?
Yes.
Can you tell me what that is?
That is the camera angle during the daytime where it faces Becky's house.
So it shows what the camera sees when it's not in the middle of the night.
Correct.
Your Honor, I'd ask that People's Exhibit 16 be admitted into evidence and published to the jury.
Any objection, Mr. Schneider? Mrs. Schneider?
No, Your Honor.
People's Exhibit number 16 will be admitted.
And again, as you described for us, this is what that camera shows during the daytime.
Correct.
Can you tell me, when we talk about the sensitivity issue of the camera, the sensitivity of the camera is set, you said it's 7 out of 12?
Yes.
So does it record all the way to Becky's house if there's movement by her house?
No, I believe it would reach out to around that rock area, that big rock, yeah.
Right there?
Mm-hmm.
And anything beyond that, the camera's set up to ignore?
Correct.
If I could retrieve those exhibits.
Here's the second.
Mr. Hyman, we've heard talk about a prowler in that neighborhood. When we talk about the prowler in the neighborhood, is that what we're talking about, that person on the video?
Correct.
Was there any issues with the prowler in the neighborhood before February 14th?
No.
And since Becky was found murdered, have there been any random prowlers in the neighborhood since then?
No.
The pool video where it's
February
on the screen
morning of the 23rd, early morning hours.
has to do with
Did you hear
all these
anything?
videos are
No,
shot
not.
by
Did you
a
see
single
anything
photographer
unusual?
No.
from WGEM
That's all the questions I have.
for the media pool.
Cross, Ms. Schnock.
Mr. Hyman, I'm going to ask you some questions, okay? If you do not hear me or if you do not understand my question, will you let me know?
I will.
Thank you. How long have you had these security cameras up at your house?
For about a year and a half.
Okay, and what was the reason for having them installed?
We had someone break into my wife's car.
Okay, and was that break-in reported to police?
No.
Okay. And with respect to so there have been, and did that happen at your house?
Yes, that happened a year and a half ago.
Okay,
yeah.
so there have been break-ins at your house prior to February 14th?
Just that one, yes.
Okay. And with respect to the recording on February 14th of 2023, did you do anything with that video as far as sharing it publicly is concerned?
Not until the cops have found Becky's body.
Okay. Did your wife perhaps share that video publicly with anybody, if you know?
No.
Okay. Did you make any social media reposts that the same guy was back breaking into one of your cars?
Yes.
Okay, and when did you make that post?
I did not.
Okay.
That was my wife. My wife has.
Okay, and
did
that was in
post.
relation to the February 14th, 2023 video?
Yes.
Okay.
She made that post, yes.
Okay. And did I understand your testimony correctly, Mr. Hyman, that you actually went outside on February 22nd in the evening and early morning hours of the 23rd?
Yes.
Okay, and what time did you go outside?
Approximately 25 minutes after the person left.
And what date was that?
The 22nd.
Okay.
The morning of the 22nd, yes.
Okay, and when you went outside, did you see anything?
No, I did not.
And did you see anybody?
No, I did not.
And prior to going outside, did you see or hear anybody?
No, I did not. I saw the videos, and that's whenever I went out there, yes.
And nothing appeared out of place, is that fair?
Nothing appeared out of place.
Okay. Did you or your wife report this person that was in your driveway on February 14th?
No, we did not.
Okay. Nothing else, Your Honor.
Redirect.
No, Your Honor.
You may step down.
We'd ask that Mr. Taylor Hyman be released from his subpoena.
Any objection, Ms. Schnock?
No, but we have him under subpoena, Your Honor, so that would still stand.
Okay. You're free
So
to go. but
you're released from one subpoena, but not the other.
Next witness, Mr. Jones or Ms. Keck?
Your Honor, the people would call Ted Johnson.
Not sure what we're admiring the lights for. They're nice lights. Fire extinguisher.
Sir, if you'll step up to the front of the courtroom. And then raise your right hand and be sworn by the clerk.
You do solemnly swear that the testimony may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do. Okay. And if you come around here and have a seat right here in this chair. Kind of scoot up to the table to where you're comfortable, and then you can bend that microphone, just make sure it's in front of you and speak towards the microphone, please. You may inquire.
Thank you, Judge. Can you tell us your name, please?
Ted Johnson.
Mr. Johnson, did you know Becky Bliefnick?
Yes.
Tell us how you knew her.
We're in a dating type relationship, but not officially exclusively dating.
When did that start?
We met, I would say, in probably January of 2022. Talked for a while as friends and gradually spent more time together and became romantically involved probably the summer of 23. No, sorry, 22. I apologize.
Did you know that Becky was going through a divorce?
Yes, yes, I did.
Did you have conversations about that divorce?
We did.
And what was the sense you got about the divorce that Becky was going through?
It was not pleasant by any means. A lot of difficulty and a lot of animosity on both sides, honestly.
By the time February 2023 had come along, what was Becky's attitude about the divorce?
She was actually very excited for it to be done. Looking forward, actually, like they had been postponed many times, and she was just looking forward to it being done and over.
Mr. Johnson, I want to talk to you about specifically the time period in February 2023 leading up to her death, okay?
Okay.
Did you communicate with Becky over the phone?
Yes.
Was that both phone calls and text messages?
Yes.
Mr. Johnson, I'm handing you several pages of what are marked as exhibit number 4. Can you review those and tell us what those are?
Text messages between Becky and I.
Do they also include a phone call that you had with her?
Yes.
Are those some text messages and a phone call that are from February 4th, 2023 to February 23rd, 2023?
Yes.
She said phone call, my phone started
Was
ringing.
exhibit 4 be admitted and published to the jury?
Ms. Knock, any objection?
No.
All right, will be admitted, may be published to the jury.
Mr. Johnson, I want to start with talking about the evening and morning of February 14th.
Okay.
On February 13th, did you spend the night with Becky at her house?
Yes, I did.
And in fact, up on the screen here, we show a message from February 13th, 2023 at 11:44 p.m. that says from 217-430-4206. Is that your phone number?
Yes.
And that was sent to 217-316-4616. Becky's phone, correct?
Yes.
And you had texted her that you were on your way.
Yes.
As you said, then you went and spent the night with Becky that night, correct?
You did, yes.
When you spent the night with her, how late did you stay there?
Till the next morning.
Do you know what time you left the next morning?
Around 5:30 a.m., I believe.
If it said you were on your way at 11:44, about what time did you arrive at her house?
I live about 10 minutes away or so, so probably midnight-ish, somewhere around there.
I'm going to have to talk just a little bit about
I apologize. About 10 minutes from then, so midnight.
So right around midnight?
Yes.
Did you park at her house at a certain spot when you go there?
Yes, I did.
Tell us what area of her house you were parking in.
To the south of the garages in the driveway.
Mr. Johnson, we're going to put exhibit number 9 up on the screen. It's already been admitted. Do you see up here on the screen where you would park when you would stay with Becky at her house?
Yes, I do.
Can you describe where that's at?
So do you have a pointer or something?
Yeah, I'm going to give you this
Thank you.
fancy.
Is it on?
It should be. There you go. You can show us where that's at.
I would park right here. This area.
Right there behind the house by the driveway.
Yes.
Thank you so much.
I can't see where it was
Is that
pointing.
where you parked at Becky's house on the evening, February 13th till morning of February 14th?
Yes, I always parked right there.
Did you and Becky have sex that night?
Yes, we did.
After that time, when was the next time that you saw Becky?
I believe I brought her some Qdoba over to her house after her surgery.
I'm going to ask
sorry.
you to bend the microphone towards you, or
Sorry.
speak towards it, because I did not understand that last answer, Ms. Keck. Could Could you please repeat your last answer?
Yes, when she got back home from her surgery, I brought Qdoba over to her house.
If we can go back to People's Exhibit number 4. This is a text that you sent to Becky on the evening of February 21st, 2023 at 7:51 p.m. It said, "Got it, on my way." Was that you bringing Qdoba back to her house?
Yes, I talked to her and she'd asked if I could pick it up for her because she wasn't able to drive yet.
When you got the Qdoba and you went to her house, how long did you stay there that evening?
Probably an hour or so, maybe a little longer.
Did you spend the night that night?
I did not, no.
Tell us, how was Becky getting around after her surgery that evening?
She was slow, but upright and moving. She was wiping down one of the tables in the living room when I got there that night. Yeah, I mean, slow but sore, but upright and moving.
When you left, what was Becky doing that evening?
I had put her to bed that evening.
You said you put her to bed.
I apologize. I helped her carry some bottles of water and some books upstairs so she could get into bed. I helped her into bed that evening, pulled her covers up over where she was going to go to sleep, and I kissed her on the forehead, and I told her to sleep well. And that's the last time I saw her.
Do you need a drink of water in bed?
If you have one. Thank you. Thank you. Thanks.
So the victim in this case was seeing the witness.
Yeah.
The victim was still going through a divorce.
Did you and Becky, you said that was the last time you saw her, did you talk to her again?
Yes, I did.
Did you also text with her?
Yes, I did.
And we can go to the next slide. The next evening, you were texted Becky at 7:16 asking her how her evening was going, correct?
Yes.
And she responded, is that right?
Yes.
And her response was, "I'm just doing laundry and paying bills and being annoyed. I can't do much of anything else. LOL."
That's correct.
And you responded to LOL, I get that.
Yes.
Then you sent another message to Becky that just said, "I just got back to my house, have a stack of bills that I need to go through myself, and all my laundry from this weekend I just threw in the wash." And that was at 7:18 p.m.
That's correct.
And she told you, "Don't wash or dry your new scrubs on high."
Yeah. Yeah, she had actually bought me a pair of new scrubs because I washed my old ones and dried them on high and they'd shrunk and were a little small. She didn't want to mess up the new ones.
And you told her at 7:22, LOL, I won't.
Yes.
Her next message was, "I'm free to drive tomorrow, exclamation mark. Pretty excited about that, LOL. Might not be too comfortable, but I'm allowed to do it."
That's correct.
You then responded at 7:26, LOL, don't push it. I know you are anxious to get back to normal, but I want you to be safe.
Yes.
It was some sort of abdominal surgery or stomach
She
surgery.
then responded, "Well, I have a lot of errands to run tomorrow, and my non-independently wealthy self doesn't allow a chauffeur, and I don't like to ask for help, as I'm sure you already know. It took me all I had to ask you to pick up food." This is where I went, winky face, I'll make it work. And that was at 7:30, is that right?
That's correct.
You responded, "Yes, I understand. BC, I'm the same way, because I'm the same way."
Correct.
At 7:32, she then tells you, "Also took a lot for me to even let you come over here and see me in my gross post-op glory. That's why I took a Valium, so I wouldn't be bothered about it."
That's,
I was referring to that before.
that's correct, yes.
And you just told her, at 7:37.
That's correct.
And also, you didn't look bad at all.
Correct.
I was expecting much worse.
Correct.
At At 9:18, Becky sends you another text getting all of your stuff done.
That's correct.
After that, then you called her at 9:47 and you guys talked for a little over 26 minutes. Is that right?
That's correct.
Tell us what you talked about during that phone call.
How she was feeling after the surgery. She was excited that she was going to get to pick up her boys the next day. She had told me that she was excited to drive, that she had done laundry, she was feeling sore but okay, that she wasn't going to take any of her pain medicine that night because she wanted to be able to drive the next day to get her boys.
In that phone call, was that the last time you got to speak with Becky?
It was.
The next morning, did you text her again?
I did.
Was that at 6:41 in the morning?
It was.
Did you tell her good morning?
Yes.
And again, not knowing that she was dead, did you then text her again when she didn't respond?
I did.
And that was at 8:13 in the morning, and you said, I hope you slept well last night.
Yes.
At that point, you had texted her 2 different times that morning. Did she normally respond to your text?
She did, yes.
And were you thinking it was weird she hadn't responded?
Yeah, I mean, I thought that was odd that she hadn't responded by that time, but I also knew she had a lot of stuff going on, so.
So then did you send her another message a couple of hours later?
I did. I hadn't heard from her. It was noon, and I still hadn't heard from her, and I thought that was odd. So I was kind of being playful and texted her Marco.
You did Marco, hoping she'd respond
On
Polo,
Polo,
right?
yes.
That was at 12:39 p.m.
That's correct.
Later that evening, did you receive a Facebook message?
I did.
Who did you receive that from?
Becky's sister, Sarah.
Based on that message, did you talk to Sarah on the phone?
I did. Sarah messaged me and said that this is Becky's sister, Sarah. There's been an emergency. Can you call me? And she listed her phone number, and I immediately called her back.
At that time, what did Sarah tell you?
She told me that Becky had been found dead in her home. They didn't really know a whole lot else, but that one of the Quincy detectives would be notifying or be contacting me.
Did one of the detectives, in fact, contact you that night, February 23rd?
Yes. Shortly after that, Detective Eddie contacted me from the Quincy Police Department.
When he contacted you, did you meet with him?
I did, yes.
Was that here at the Quincy Police Department?
It was, yes.
When you met with Detective Eddie, did he ask you several questions?
Yes.
And by several, I mean, did you meet with him for multiple hours?
Yes. Close to 4, I believe.
Did you answer all of his questions?
Yes, I did.
Did he also ask you during that meeting if they could take a picture of your shoe?
They did, yes.
And you allowed that?
Yes, ma'am.
Did they also take a picture of your shoe with a scale next to it?
Yes, ma'am.
Did they also ask you to submit to gunshot residue testing?
Yes.
Did you agree to do that?
I did.
Did they ask you to have a DNA follow swab done inside your shoe?
Yes, they did.
And did you agree to that?
Yes, I did.
Did they ask you about looking at your phone?
Yes, they did.
And did you let them look at your phone?
I did.
And did you tell them you were concerned because you believed you had accidentally deleted some of your messages with Becky?
I did, yes.
Did they, in all their police wisdom, say you know how to still get those messages and they were able to retrieve all of the messages?
Yes, they were.
And many of those messages are the ones we just looked at?
Yes, ma'am.
Did they also ask you if you owned any firearms?
They did.
Did you tell them about any firearms you owned?
Yes, I did.
And specifically, do you own a handgun?
I do.
What caliber is that handgun?
It's a .40 caliber Smith & Wesson.
Do you currently own a 9mm handgun?
I do not.
Have you ever owned a 9mm?
I have.
When was that?
More than over 2 years ago.
What happened to that 9mm handgun?
My ex-wife was awarded it in our divorce.
And you gave it to her after it was awarded to her?
Yes, ma'am.
And so the last time you saw it was after she was awarded the gun?
That's correct.
In your time that you saw Becky and went to her house, did you ever know Becky to own a firearm?
No, ma'am.
Did you ever see a firearm in her house?
No, I did not.
You said that you own firearms yourself. Do you keep those firearms in a safe?
Yes, I do.
Did you ever see any type of firearm or gun safe in Becky's house?
No, I did not.
defendant's in the white shirt closest to us in this picture, looking away.
Mr. Johnson, I want to go back to talking about where you parked on February 13th, okay?
Okay.
February 14th. Mr. Johnson, I'm going to show you what we marked as exhibit number 5. Can you tell us what that is?
It's a picture of my truck.
Is that the same truck that you were driving in February 2023?
Yes.
Is that the same truck that you parked at Becky's house the evening and morning of February 13th to February 14th?
Yes.
Your Honor, I ask that People's Exhibit number 5 be admitted and published for the jury.
Any objection, Ms. Schnott?
No.
People's number 5 will be admitted, and you may publish it.
In February of 2023, did you have Missouri license plates at that time?
Yes, I did.
You previously lived in Missouri?
Yes, I did.
I'm going to hand you what's been marked as People's Exhibit number 6. Is that a picture of the license plates that you had in your truck February 13th to February 14th, 2023?
Yes.
Your Honor, I ask that People's Exhibit number 6 be admitted and published.
Any objection, Ms. Schnott?
No.
Will be admitted and published.
The license plate number on that is Missouri license plate 8DCJ55. Is that correct?
That's correct.
Mr. Johnson, I'm also going to hand you what's been marked People's Exhibit number 7. Can you tell us what that is, please?
That's the VIN number on the dash of my truck.
And that VIN number, that picture is actually taken from the outside of the truck looking in, correct?
That's correct.
Your Honor, I ask that People's Exhibit number 7 be admitted and published for the jury.
Any objection, Ms. Schnott?
No.
Will be admitted and published.
And there's a glare, obviously, from the picture, but you can see the VIN number right there through the window of your truck looking into that dashboard. Is that correct?
That's correct.
And that 16-digit VIN number is specifically assigned to that truck.
That's correct.
Finally, I'm going to hand you what's been marked as People's Exhibit number 8. Can you tell us what that is, please?
It's the manufacturer information from the driver's side door of my truck.
Your Honor, I'd ask that People's Exhibit number 8 be admitted and published for the jury.
Any objection, Ms. Schnott?
No.
Will be admitted.
And that information correlates with the VIN number that you can see from the outside of the truck looking in. Is that right?
That's correct.
And for the record, the VIN number of your truck is 5TFA5F1XMX984278. Is that right?
That's correct.
All right, I have no other questions for Mr. Johnson. Thank you.
Cross, Ms. Schnott.
Thank you. Mr. Johnson, if you can't hear me or if you don't otherwise understand my question, will you let me know?
Yes.
Thank you. Sometimes attorneys ask bad questions. Am I understanding the characterization of your relationship with Becky as a non-exclusive sexual relationship?
We were not exclusively dating, no.
Okay, so were you seeing other people in February of 2023?
Talking to.
Okay.
But, I mean,
Sure.
yeah, we're not exclusively dating, but I wasn't exclusively seeing anyone else either, no.
Okay. Were you sexually active with anybody else in February of 2023?
No, ma'am.
Okay. As far as the week of February 23rd is concerned, you knew that Becky was having surgery earlier in that week, correct?
I did, yes.
And there weren't a lot of people that knew that she was having surgery that week, correct?
Not that I know of. I don't know, ma'am.
Okay. Did you know where she was having surgery?
St. Louis.
Okay. And did you know if she had arrangements for her kids that week?
She had told me her kids were staying with Tim Wednesday night because she was not released yet.
Okay. And normally the children would stay with Becky on Wednesdays, correct?
That's correct.
Okay. And she made this arrangement with Tim. And there was, as far as you know, there were no issues making that change to their parenting time schedule. Is that fair?
Not that I'm aware of, no.
Okay. And so Tim didn't even know that she was having surgery that week, correct?
That will be sustained.
I don't know.
And you knew that she didn't have her kids at home that week, correct?
Wait.
I apologize.
That's okay. The jury will, or the record will, I have that last answer stricken, and the jury should disregard that last answer. Now you may proceed, Ms. Schneider.
Thank you, Judge. You knew that she didn't have the boys home that week, correct? At least Monday and Tuesday. And
she was
Wednesday.
not home on Monday. Her surgery was Monday.
Right, and so she didn't have her boys earlier that week, correct?
Yes, she was in St. Louis,
Okay, and then she didn't have the boys Wednesday, correct?
to my knowledge.
Okay. And you also knew that she had been taking Valium after her surgery, correct?
I did not know if that was what was prescribed to her, no.
Okay, even though she said it to you in one of the text messages that you just talked to us about?
She did state she took one, yes.
Okay, so you knew that she was taking controlled substances?
At that time, yes.
Okay, and also at this time, you were holding over $13,000 of her cash in your gun safe, were you not?
I'm not aware of what was in the bag, ma'am.
Okay, did you ever see the contents of that bag?
Only when Detective Eddie pulled it out of my safe and unzipped it.
And
But
there was several thousands of dollars in cash in that bag, was there not?
I don't know how much was in it, ma'am.
There was cash in that bag, correct?
I saw that there was cash in the bag.
And that bag had her name on it, correct?
I do not know if it had her name on it.
Did the bag have any identifying characteristics on it that it belonged to Becky?
It was blue.
How long had you been holding on to that bag for her?
Month or two?
Did you have a code or a key to get into Becky's house?
No, I did not.
When you would go to Becky's house, how would you get into her house?
Usually the sliding door to the east, but it had been broken for the past couple months, didn't open or something.
Okay.
So the garage door was open.
Okay.
The door through the garage.
Okay. As far as the day, well, you mentioned that there was animosity on both sides of the divorce with respect to Tim and Becky, correct?
Yes.
And other than the divorce, Becky didn't disclose any other problems or fears that she was dealing with recently, correct?
No.
As far as February 23rd is concerned, did you go to work that day?
I did, yes.
And what time did you go to work that day?
7 a.m.
And what time did you leave work that day?
After 4 sometime.
Okay, and
Probably
what did
between
you do?
4 and 5.
What did you do after you left work?
I went to my parents' house, I believe, and fed horses. We have livestock.
Okay. Did you make any trips to Kirksville, Missouri that day?
On the 23rd? I don't know. I mean, it's possible. I don't know off the top of my head, sorry.
So you don't know?
On the 23rd? I don't believe I went to Kirksville on the 23rd, no.
Okay, did you go to Kirksville on the 22nd?
Honestly, I don't remember.
When did you
I did
go to-
recently go to Kirksville to meet with the guardian ad litem for my children, yes.
Okay, and that's what I was going to ask you.
Okay, sorry.
Sometime around the time Becky was murdered, you were traveling to Kirksville to meet with your divorce attorney, correct?
I believe it was the guardian ad litem. But
Oh, I apologize. And was that to deal with the issues that you and your ex-wife were dealing with?
yes, we were in a change of custody.
Okay, and had that been going on for some time?
About a year, yes.
Okay. Do you know, after you said that you went to your parents' house and you took care of some of their horses, correct?
Theirs and mine, yes.
Okay. And did you meet with anybody else or speak with anybody else that evening?
I don't believe so.
Okay.
Well, I talked to my dad. He was at the house.
Okay. The day before Becky passed, which would have been Wednesday, you did not go to Becky's house at all that Wednesday, correct? That would have been the 22nd?
I don't believe so, no.
Okay. Did you meet with any friends or family members that evening?
On the 22nd? Yes, I did.
Okay. Did you have a friend named Heather come over to your house?
Coworker, yes.
Okay. And was your friend Heather there from about 6 to 7:30?
Approximately, yeah.
Okay. And then later that night, would you have made a phone call to Becky?
Yes, I did.
Okay. And then do you know the night that she would have been murdered, which would have been Wednesday night going into Thursday, did you ever leave your home Wednesday evening going into Thursday morning?
I don't recall.
Okay.
No.
Is there anybody that stayed at your house that night?
No, ma'am.
Okay. Were you aware of any security system that Becky had at her house?
I know there was a security camera in the garage by the door.
Okay.
I had seen it when I'd come in through there.
Okay. Is that the only camera that you're aware of her having?
Yes, that's correct.
And you said that in one of the last conversations that you had with Becky, she was really excited to be able to pick up her kids from school the next day, which would have been Thursday, correct?
That's correct.
And she mentioned that she didn't want to take her medication because she wanted to be able to drive to go pick up the boys, correct?
That's correct.
No other questions, Judge.
Redirect.
Oh, thank you, Your Honor.
You may step down.
Thank you, sir.
Your Honor, we'd ask that Mr. Johnson be released from his subpoena.
All right. Any objection by the defense?
No, but we have him under subpoena as well,
Okay.
Your Honor.
All right. You're released from the people's subpoena. You're still under subpoena by the defendant, all right? Okay, thank you. Call your next witness.
So he can't
People would
watch
call
the
Matt
case.
Hermsmeyer.
Okay, while we're waiting for Officer Hermsmeyer, you may all stand up and stretch for a minute, all
Oh,
right?
it's yoga time. We need some yoga music. I'm not sure if they're dismantling the jury box right now at the same time as well.
Okay.
A little stretching. I think I hear somebody doing jumping jacks there in the background. Pop the back, pop the neck, roll the shoulders.
You're too quick.
Okay, please be seated.
This courthouse is falling apart.
Come around here and have a seat in this chair.
We have an officer.
You may inquire.
Thank you, Your Honor. Can you tell me your name, please?
Matt Hermsmeyer.
And Mr. Hermsmeyer, what do you do for a living?
I'm a Quincy police officer,
Officer Hermsmeyer, how long have you done it?
25 years.
What is your current role with Quincy Police?
Patrol officer.
What does that mean? What's a patrol officer?
Take calls for service from the general public.
I want to talk to you then about February 23rd, 2023. On February 23rd, 2023, around 3:30, 3:45 p.m., did you receive a dispatcher call for service?
I did.
And what was the nature of that dispatch? What was the call that you were going to?
Assisting the ambulance with a death investigation.
What was the location of that?
2528 Kentucky Road.
According to the dispatch note that you had, what were you told about the nature of this death investigation?
That a family member found another family member deceased, and our dispatch tickets are somewhat difficult to read sometimes, but I did see possible suicide.
When did you arrive at 2528 Kentucky Road?
Approximately 3:33 p.m.
14 shots is a
I'm
suicide?
going to hand you what's been marked as People's Exhibit 18. I'm going to ask you if you recognize that officer.
I do.
Can you tell me what that is?
This is the house located at 2528 Kentucky Road.
Does it show the house as you observed it on February 23rd?
Appears to be, yes.
Your Honor, I'd ask that People's Exhibit, give me the exhibit.
18.
18.
18 be introduced into evidence and published.
Any objection, Ms. Schnock?
No.
It will be admitted and may be published.
Officer Hermsmeyer, is that a one-story house, two-story house when you walked in? What did you see?
Two-story house.
So there's a ground floor and upstairs. Is there also a basement?
I don't know. I was primarily on the second floor.
Did you go, in fact, to the second floor?
I did.
I'm going to hand you what's been marked as People's Exhibit 17 and ask you to describe what we're looking at here.
This is a diagram of the second floor to 2528 Kentucky Road.
And I understand it's not to scale, but apart from not being to scale, does that appear to be an accurate diagram of at least the area of investigation?
It does.
Your Honor, we ask that People's Exhibit 17 be introduced.
They are going to show a picture here that will include the victim. I've been told that it is not gory. Just be aware.
When you went inside, you went up the stairs that are up top of this diagram. Is that right?
Yes.
And then where did you go?
We walked down the hallway to the opening door of the bedroom, which is located on the west side of this house.
So you went up these stairs and then went down this hallway. Is that right?
Yes.
And then you turned to your left and looked in that bedroom.
That's correct.
When you looked into that bedroom, at that point you had been told that it was a possible suicide.
Yes.
When you looked into that bedroom, did you notice anything that made you believe that this was not a possible suicide?
Yeah, I did.
Tell me what you noticed.
There were several, approximately 6 to 7 spent shell casings on the ground, on the floor, in the bedroom.
And why would that mean to you that that might not be a suicide, officer?
Suicides are typically a one shot.
When you walked a little bit closer to that door, to that bedroom, did you notice anything about the door that concerned you or troubled you?
There's damage to the door and pieces of the wooden frame on the ground.
Did it appear the door had been broken into, kicked in, pushed in?
Yes.
I'm going to hand you what's been marked as People's Exhibit 37, 45, and 47.
Excuse me, Mr. Jones, give me those again.
37, 45, and 47.
Okay, thank you.
Do you recognize those photos?
I do.
Can you tell me, start with 35.
37.
37.
Yeah.
Give it to you, I don't have any more. 37, can you tell me what that is?
This is the door leading into the bedroom.
And when you look at that photograph, tell me what you noticed about what you observed, not only in that photograph, but when you first got on this.
There was damaged wood casing from the door on the ground, in addition to spent shell casings.
Multiple spent shell casings?
Yes.
Your Honor, we'd ask that People's 37 be introduced into evidence and published to the jury.
Any objection, Ms. Schnock?
No.
37 will be admitted and may be published.
Okay, just trigger warning. We might have a little bit of video here that includes the victim's body.
When you talk about the damage to the door, are you talking about the wood pieces that are seen where the laser pointer is pointed?
Yes.
And you also talked about spent shell casings. Are you talking about the shell casings that are here in the middle of the floor?
Yes, I am.
People's 45, if you could look at it, and again, tell me what you're looking at there.
This is a closer up picture of the previous picture with the damaged wood and spent shell casings on the ground.
Different angle?
Yes.
Your Honor, we'd ask that People's 45 be introduced into evidence and published.
Any objection?
No.
45 will be admitted and may be published.
This view is basically head on to that door frame, is that right?
That's correct.
And you see the door frame basically shattered, is that fair to say?
Yes, it is.
And the pieces of the door frame here on the ground?
Yes.
And 1, 2, 3, 4, 5 shell casings in that general area.
Yes.
Can you look at People's 47? Tell me what you're looking at there.
This is if you were standing inside the bedroom, taking a picture of the door with the damage on the ground, and then there's a door to the right side of this picture that's the opening to the bathroom.
And when you looked into that bathroom door, did you notice anything?
I did.
What did you notice?
A white female laying on her back on the floor.
Your Honor, we'd ask that People's 47 be introduced in that.
Okay, I'm going to cut away if it's bad.
No.
I've been told it's not.
It will be admitted and may be published.
And again, Officer Herzmeyer, the broken pieces of wood here that we're talking about,
Yes.
and then 1, 2, 3, 4, 5, 6 shell casings in that. 7, 1, 2, 3, 4, 5, 6, 7 shell casings in that general area. Is that right?
That's correct.
And is there a piece of the broken door also underneath the door there?
Yes, that's part of the doorknob mechanism.
Did you also look behind that door?
I did.
When you looked behind that door that I'm pointing to with the laser pointer, did you notice anything?
Yes, there's a cell phone behind the door on the ground.
Can I hand you what's been marked as People's 48? Is that a photograph of that cell phone behind the door?
It is.
Your Honor, we'd ask that People's 48 be admitted and again leave a court to publish to the jury.
Any objection is not.
No.
48 will be admitted and may be published.
Is this the cell phone that you're referring to?
Yes, it is.
Appears to have been dropped as the door was violently shoved open. Fair to say?
Yes.
I want to talk to you about a different area of the house. Could you go back to People 17, please, Ms. Brown? Were you also in this east bedroom area where the camera is pointed?
I was.
When you were in that area, did you notice a bedroom window?
I did.
And did you notice anything about that particular bedroom window?
It was cranked open and the glass was broken.
I'm going to hand you People's Exhibit 26, 27, 28. People's 26, People's 27, and People's 28. I'm going to ask you if you recognize that.
I do.
What is that?
This is the east bedroom on the diagram.
And when you looked at that window, you told us that the window appeared to be broken, the glass was broken in it?
Yes.
And did those photographs accurately show what you observed in that east bedroom?
They do.
Your Honor, I'd ask that People's 26, 27, and 28 be introduced into evidence, admitted into evidence, and leave to publish to the jury.
Any objection is none.
No.
26, 27, and 28 will be admitted and may be published.
For the record, we're now looking at People's Exhibit 26. Is this the window that we're referring to?
It is.
Did you also notice something on the ground where the laser pointer is now pointed?
There appeared to be a partial foot impression made by either a shoe or a boot.
Moving on then to People's 27. People's 27. Is this a close-up of that broken window?
It is.
And do we see some damage in this bottom area?
Yes,
And also you told us the glass was broken.
it was.
And People's 28. Is this the view of the upper portion of the window?
Yes,
And again, we see some damage in this upper right-hand corner of the window,
yes,
and the glass was broken.
that's correct.
I now want to move on, if you could go back to 17, please, Ms. Beth. Did you also go into that bathroom in this general area?
I did.
When you went into that bathroom, tell me in a general sense what you saw.
A deceased white female laying on her back.
I'm going to hand you what has been marked as People's Exhibit 51, 52, and 53. I'm going to ask you to look at those, and then I'll ask you some questions.
Okay, I've been told these pictures may show the body, but it's not gory. If I determine it's too gory, I'm going to cut away to my own picture.
If we could start with People's Exhibit 51, could you tell me what People's Exhibit 51 shows?
This is a white female, later identified as Rebecca Bliefnick, laying on her back on the bathroom floor.
Does it accurately show what you observed when you were the first officer on scene?
It does.
Your Honor, we'd ask that People's Exhibit 51 be introduced into evidence and published to the jury.
Any objection, Ms. Schneider?
No.
51 may be admitted and can be published.
Officer, when you were on scene, did you notice several pieces of small plastic around and on her body?
I did.
When you were in that bathroom, did you look at Rebecca's genital area?
Yes.
Were you able to see her underwear?
Yes.
Did you make any observations of her underwear?
There appeared to be some type of a towel underneath her underwear.
Did the underwear appear to be pulled to either side?
No.
Did the underwear appear to be torn in any way?
No.
Looking then at People's Exhibit 52, it's not been introduced yet, 52, is that a close-up of the genital area?
Yes.
Does it show the underwear that you observed?
Yes.
And the towel that you observed?
That's correct.
And then look at People's 53. Is that a close-up or a closer-up view of the same thing?
It is.
Does it accurately show what you observed on
I'm not going
February
to show these pictures.
23rd, 2023?
It does.
Your Honor, we'd ask that People's Exhibits 52 and 53 be introduced to that.
Any objection, Ms. Schneider?
No.
We'd ask to leave to publish People's Exhibit 52 and then People's Exhibit 53.
People's Exhibits number 52 and 53 will be admitted, and then they may be published.
Now on the screen, we're looking at People's Exhibit 52. And officer, in this, where the laser pointer is pointed, is this what you're referring to as the Becky's underwear?
Yes.
And then off to the
She was
left
found by her
side
dad.
of the body, the right side of our screen, there appears to be a blue item, the blue towel that you're referring to.
Yes.
Now, what was under that blue towel, you have no way of knowing. Is that fair
I
to
don't.
say?
Correct. I don't know.
Moving on to People's Exhibit 53, is that a close-up of that same view?
It is.
And again, we see some small pieces of plastic on her body.
That's correct.
It's not indecent, but it's.
Underwear and that.
We don't need to zoom in on these pictures.
That's correct.
Now, officer, how are we able to see the victim's underwear when we can see that she's also wearing pants?
The pants did not appear to have a middle or a crotch area.
When you observe the pants, do they appear to be ripped or torn at all?
They did not.
In fact, are there seams on those pants to show that those pants are designed to be crotchless in a sense?
There were.
Blank screen, please. Let's go. I could have just one moment.
You may.
Thank you, Officer Hermsmeyer. That's all the questions I have.
Questions, Ms. Schneider?
Thank you. Officer Hermsmeyer, what time did you arrive at the Bliefnick home, if you recall?
Approximately 3:33 p.m.
All right. And when you got there, who else was at that residence at that time?
I made contact with, I was field training a new officer that day. When we arrived, we made contact with 2 Adams County paramedics and a gentleman that was later identified as William Postal, who is Becky Bliefnick's father.
Okay. And after you arrived, was the house secured?
After I arrived, we checked the upstairs for anyone else in the house, and I stayed upstairs in a cover position while another officer came to search the rest of the house with Officer Landis, who I was training.
Okay. How long did you spend at the Kentucky Roadhouse that afternoon and evening?
Approximately 6 hours.
Okay. And what essentially did you do for those 6 hours? I mean, you told us about what happened when you got there and what you observed when you found Becky on the floor. I'm guessing that didn't take 6 hours, correct?
That's correct.
All right. So what did you do, or what was your involvement in the investigation after you found Becky?
I contacted Sergeant Elvis by phone and asked him to notify our investigations unit and to send additional officers to search the house so no one else was in there.
Okay. Did you go door to door and speak with any neighbors in the Kentucky Road area on that afternoon?
I did not.
Okay. And you did not have any conversations with Tim that afternoon, correct?
I did not. That's correct.
All right. And as far as the footprint or the foot impression is concerned, do you know if you were the first person to come across that footprint?
I was.
Okay. And what was done with that footprint or foot impression, if you know?
I don't know.
Okay. Is it fair to say whoever came through that window made that impression?
Objection, Your Honor. Calls for speculation.
That will be sustained.
Did the window still have lattice in it? Did it have any lattice work or anything like that, if you recall?
I don't remember.
Okay. And do you know, was the window completely broken out, or was there still glass in the window frame?
There was still glass in there.
Okay. And was that on the inside of the window or on the outside of the window?
I don't remember.
Okay. Do you know how many officers were at the Kentucky Roadhouse that evening?
If I had, guessing, a dozen.
I don't have any other questions for Officer Hermsmeyer, Your Honor.
Redirect?
No, Your Honor.
All right, you may step down.
You want these left here?
Your Honor, we would release Officer Hermsmeyer from his subpoena.
All right. Ms. Schnock, any objection?
No.
All right. You're free to go. Counsel, step up here just for a second.
The bailiff is wearing a polo shirt, which is cool, but it just seems rather casual in a court setting. It's a polo. I think he's got a. I'm not sure if he's got an actual badge on it or if it's a sewn-on patch. Both work. I'm sure it's an official uniform shirt, but it just seems very casual for the court setting. Think they're going to have a break here. Let's see.
All right, ladies and gentlemen, we are going to take a recess. It will, you'll have 20 minutes then to make sure you have time to use the facilities and get a snack or something, and we will continue with the people's case. We'll be in recess. All right.
Hold tight just for a minute. Let's make sure we get skip to the next part. Mendy Lou gifted a membership. Just went to Amber. Thank you so much. That's awesome. Congratulations, Amber. Okay, let's see. Ready? They're staring at the ceiling, so it's not a fun picture to look at. So it just looks like a white screen. Yes, they did. She was wearing pants that were more like chaps. That's
2:25, and we will start back up again.
That's the noisiest. The noisiest bench, chair. I don't know what it is.
Sure, that's what.
Yes, yes, recognition. That he shoots his hand.
Okay. Yeah. Right. I knew I knew you from somewhere.
I see you on the Facebook. It's on Facebook.
Okay.
Hot mic.
So we trying to decide a career path.
Pool videos are when a lot of media wants to film a trial and the judge only allows one camera in. That is the pool camera. Then everybody gets the footage from that one camera. So WGEM was the one camera that's allowed in.
I've been able to sit where I can make a court reporter is now just trying to get a court experience.
Yeah, I know we need them.
That's what I would if you need to, don't change your minds. Try not to.
Still holding out.
Do you need me?
Let's see if there's anything juicy here. Boost the audio a bit. He said a 20-minute break. I thought it was cut out. I can fast forward here if you want.
Yeah. No, it's funny because I recognize it.
This is in Illinois. We're in Illinois, and Illinois had passed a law recently that's safety or something. I forget what it is, the name of the law. But basically it has to do with, it changes how bail works, it changes how people sit in jail, and the end result, my understanding, which it's sort of specific just to Illinois, is that trials get heard much faster. So here we have a murder trial that's being heard the same year the murder occurred. She was actually killed in February, and now here in May we're underway with trial. So very fast, very fast. I'm going to see if I can fast forward through this just briefly.
Thank you.
Okay, let's bring that up. Skipping ahead. We're probably missing some great chat about Facebook and lawyer conferences. What do lawyers do for fun? Matthew, can you help us out? What do lawyers do for fun? That's what they're talking about, I'm sure. Still skipping ahead. Okay, they're showing us the lights again now, so the view's changed, but still not there yet.
Session court is now reconvened.
Oh, there we go.
You may be seated.
Thank you, Ashley.
Right, we are continuing with the evidence on the people's case in chief. And Mr. Jones, you have another witness today, or Ms. Keck?
Your Honor, the people would call Sarah Riley.
We might not be able to see this witness either. I'm sure the cameraman knows which ones he's allowed to film and which ones he's not. That was 20 minutes. I clicked a lot. That was a 20-minute break. We fast forwarded.
Ma'am, if you'd step up to the front of the courtroom. And then raise your right hand and be sworn by the clerk.
You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God.
Okay, and now if you could come around here and have a seat right here in this chair.
This is what
kind of scoot
people
up
have been
to the
calling the
table
Family
where you're
Feud murder.
comfortable.
It has
And
very little to
bend
do with
that
Family Feud, other than
microphone
the
down so it's in
defendant
front of you and speak
was once on
towards it,
Family Feud.
please. You may inquire.
Thank you, Your Honor. Can you tell us your name, please?
Sarah Riley.
Can you spell that for the court reporter, please?
SARAHREILLY.
Ms. Riley, where do you live at?
The address?
You know, the city or the state?
Irvington, New York.
Ms. Riley, can you tell us, did you grow up here in Quincy?
Yes.
Do you have any siblings?
Rebecca Bliefnick.
And call her Becky, is that right?
Yes.
Was Becky older or younger than you?
Younger.
What's the age gap between the two of you?
About 16 months.
So were you pretty close growing up?
Absolutely.
And were you still pretty close up until her death?
100%.
Becky was married, is that right?
Yes.
Who was she married to?
Tim Bliefnick.
Do you see Tim Bliefnick here in court today?
Yes.
Can you point him out by where he's sitting and what he's wearing?
The yellow tie, white shirt.
Your Honor, the record could reflect that.
Same tie.
The record will reflect that the witness has identified the defendant.
Ms. Riley, how did Becky meet the defendant?
They met in college. They both went to Quincy University. Tim played football there. They started dating at some point after that. Early on in their relationship, they moved to Chicago, where Tim was living at the time. They then moved to Fort Wayne, Indiana, and got married at that time and bought a house in Fort Wayne.
You said they got married. Do you know when their wedding date was?
September, 5 years after my husband and I got married, 2009, I believe.
September 2009. Do they have any children?
They have 3 boys,
Can you tell us the names of those 3 boys?
Deacon, Grayson, and Arlen.
Deacon is 12, is that right?
Correct.
Grayson is 10.
Yes.
And Arlen is now 6. He was 5 in February of this year, is that right?
Correct.
You said that
Our kids
Tim was a
also,
football
their
player
last
in
names all end
college.
with N.
Did he continue to be athletic and into working out after they got married?
Objection, Your Honor. I don't know what information she has to lay a foundation for this testimony. I'm also not convinced that his fitness after graduating college is relevant to this matter.
Ms. Keck?
Your Honor, I didn't lay a foundation and it is relevant due to the way that we believe the crime occurred.
The court is going to overrule the objection at this time. You may proceed.
Thank you. Ms. Riley, were you aware if Tim continued to be involved in working out after college?
Yes, he did. Fitness was a huge part of his life, and Becky's as well. They owned a CrossFit gym together. Tim was a coach at that gym. I know Becky also taught CrossFit kids classes at that gym. As far as I know, Tim has continued up until this point to be involved in fitness and CrossFit and working out. When we visited the house, he was often going to the gym to work out.
And when you said when they visited the house, was that the house that they lived at on Kentucky Road?
It was, yes, and any of their houses.
So before that as well?
Correct.
When did they move to Quincy?
They moved to Quincy shortly after Deacon was born. So I'd say maybe about a year after Deacon was born, they moved back to Quincy. Yes.
Did your sister inform you that she believed that the defendant was going to be divorcing her at some point in 2020?
About 7 or 8 months prior to when Tim filed, she had spoken with me on many occasions about the impending divorce. She had requested for a long time before that even that they go to marriage counseling, that they try to amend their relationship for the sake of the kids. Her goal was that they stay together as a united family for the boys. But she knew that Tim had mentioned to her that he was planning on filing for divorce. It just took a long time for him to actually do so.
what's been previously marked as People's Exhibit 69. Do you recognize that?
This is Becky's Facebook page.
And that Facebook page, does it have a picture that you know to be your sister?
That is Becky, yes.
That Facebook page, were you friends with her on Facebook?
I was, yes.
Were there regular posts, updates about her and the children?
Yes, she often posted about her and the boys' activities. Every so often she would post about nursing or, you know, a meme from time to time, but the primary focus of her Facebook page was her and the boys, yes.
Your sister was a nurse?
She was, yes.
And when she would post about the boys, would that include pictures of your nephews?
Yes.
Your Honor, I'd ask that People's Exhibit 69 be admitted and published for the jury.
Any objection, Ms. Schnock?
No.
It will be admitted and you may publish it. 69 is the exhibit.
And the picture that we see on that profile picture, that was the picture that Becky had on her Facebook page at the time she was killed. Is that correct?
Yes.
Ms. Riley, did your sister also have a phone number at the time that she was killed?
Yes.
And has she had that phone number since at least they moved back to Quincy in 11 years ago?
For as long as I can remember, yes.
Was that number 217-316-4616?
Yes.
Did you communicate with her with that phone number?
On a regular basis.
When you communicated with her, what type of communications did you have?
Many texts and frequent phone calls.
The lawyer stepped away from the
Was
mic.
there communications that you had with her via text message in September of 2021?
Yes.
That specifically, was there messages that were sent between you on September 4th, 2021?
Yes.
And handing you what's been marked as People's Exhibit 71, can you tell us what that is?
This is a text that Becky sent to myself and my husband Brett regarding fear for her life.
And does that message talk about her mom and dad and your mom and dad?
She said that she would
I
not.
don't want you to read the message, does it refer to
Yes.
mom and dad?
Yes.
Your Honor, I'd ask that People's Exhibit 71 be admitted and published for the jury.
Ms. Schnock, any objection?
Yes.
Okay. The objection that was made pre-trial, the court has ruled on that. The court recognizes the objection but overrules the objection, and that may be admitted. Number 71 may be admitted over objection and published to the jury.
This is equivalent to Mark Jensen's wife letter. That's what they're letting in right now. It's a text from the victim saying, basically, if I die.
That message, you want to make sure I get it right, okay?
Here's to look
Becky
at.
says, if something ever happens to me, please make sure the number one person of interest is Tim, as that is who would do something to me. I'm putting this in writing that I'm fearful he will somehow harm me, come after me, or will try to something to me that takes away from the kids or the kids away from me. He already has lied multiple times to paint himself as a victim and me as the perpetrator when it is absolutely the other way around. No, I have not said this to Mom and Dad because I don't want them to be out of their mind with worry. Is that the message your sister sent to you?
Yes.
Ms. Riley, I want to talk to you about the day that your sister was found dead, okay? Tell us when you learned what had happened to Becky.
My family was in Florida on vacation for February break, and I was at a hair salon getting my hair cut when my mom called my phone. And because I was getting my hair cut, I let the phone go to voicemail, knowing that in about 10 minutes I would be done. Immediately thereafter, my daughter, who was not with me at the time, called me, and because of the proximity of the phone calls, I picked up, and she said, "You need to call Grandma, she's crying." And so I did. And when I called, my mom picked up right away, and all she said was, "Becky is dead. Becky's dead. We don't know anything, but Becky's dead." And she said, "I have to call you back. Dad's not here. I have to call you back." And so I immediately called Brett, and my husband, and he was at a client's house installing a sculpture or a painting, and right away I told him, "It's an emergency, pick up," because I left him a message, and he called me right back.
Were you aware at the time that your sister was seeing somebody?
Yes.
That was Ted Johnson?
Yes.
Did you later contact Mr. Johnson?
After speaking with my mother shortly thereafter, she said, "We don't know anything." And even after she got to the house, I was reunited with my father. He did not tell her what he saw. And so in all of our conversations on the day that Becky was found, she and I were in the dark. We did not know what happened. And in the process of trying to figure out what happened to my sister, I said, "I will call Ted," because they talked every day, multiple times a day, and he may know what happened to her.
Murder took place this year, February 23rd. It's a very quick trial.
Did you ever have any conversations with your sister about her having any fights with Mr. Johnson?
The only thing remotely relevant would have been a conversation that I had with her. I don't remember the time frame, but she was upset because she didn't know if he valued their relationship as much as she did at that moment in time. And neither of them had wanted to put any sort of...
Your Honor, as to what either party wanted out of this, that calls for speculation.
Sustained. You might rephrase the question and ask again, Ms. Keck.
Fair to say, Ms. Riley, the only time we ever heard was that she thought that they thought different things about their relationship. That was their only disagreement.
Correct. And she had told me that she did not want to go public with the relationship until the divorce was finalized.
Did she ever express any fear about Mr. Johnson?
No.
She never sent you a message like what she sent on September 4th, 2021 about the defendant?
No. She told me that she loved him.
No other questions, Your Honor.
If you watch carefully, the bald attorney seems to be affirming the answers from the witness.
Am I correct in that it has been several years since the last time you saw Tim?
The last time I was in the same room as Tim was during our Christmas vacation of 2019.
And so at the time this message was sent to you, September 4th of 2021, it had been nearly 2 years since you had seen Tim in person, correct?
Yes.
And today, I can assume is the first time that you've seen him as well?
Correct.
And so you have not seen him or spoken to him since 2019, fair?
Correct.
Okay. And after Becky's passing, you had an interview with, I think, Detective Cowick, correct?
Yes.
And during your interview with Detective Cowick, he asked you, or I don't know if he asked you, but you described what type of person Becky was, correct?
I'm sure I did.
You described her as an alpha female. Does that sound correct?
Becky was strong-willed.
She was not the type of person that would be pushed around or controlled. Is that fair? It's a yes or no question, ma'am.
Like I said, Becky was strong-willed. I don't know what she would be willing to put up with in any given situation.
So she was a strong-willed alpha female. Is that how you described? That's how you described her to Detective Cowick, correct?
If that's what I said in the interview, then I will say yes.
And at the time you sent this message to Becky in 2021, you had known Tim for 15 years at that point?
Since approximately 2009, yes.
Okay. And in your interview with Detective Cowick, you indicated that you had, in the time that you knew Tim and Becky together, that you had never witnessed anything firsthand with respect to any physical altercations between Tim and Becky, correct?
I did not see a physical altercation.
Okay. And when you and Becky were talking about the disagreement that they had with respect to the relationship with Ted Johnson, that was in response to Becky seeing something that he posted about a different woman, correct?
I think that Becky had seen a social media comment on another person's picture.
And that made her question what he thought their relationship was.
Yes.
And as far as you know, that was the biggest argument that they had, or at least she made you aware of. Is that fair?
I do not think that it was an argument. I think it was a discussion.
Disagreement.
Discussion.
A disagreement about the status of their relationship. Is that fair?
Your Honor, she's answered.
That will be sustained, has been answered.
And when you talked to your mom on February 23rd, she didn't know anything, fair? You said it. She told you her statement was, we don't know anything, we don't know what happened.
Correct.
And that was correct, or that was true when she called you initially, and that was true when you talked to her when she was at Kentucky Road, correct?
Correct.
Okay. And you never sent this message to either your mom or your dad, correct?
Correct.
And you never forwarded this message to any of her attorneys, correct?
No, I did not.
And you did not report this message to law enforcement or anybody else for that matter. Is that fair?
I did not.
No other questions, Judge?
Let's see what they ask.
Redirect.
Yes, Your Honor, thank you.
These attorneys all sit at the same long table. So the lady in blue is right next to the...
The text message to law enforcement after Becky was found dead and killed, is that right?
Between my husband and I's phone, that message was provided to police.
The questions, Your Honor.
You may step down.
I'm not sure why she had to stand up to ask that. That's interesting.
And then
Your Honor, we would release Ms. Riley from her subpoena.
All right, and any objection, Ms. Schnock?
No, Your Honor.
All right. You're released from your subpoena. You may stay or go as you please.
I think we're about done with today's testimony.
Your Honor, I apologize. I did not anticipate things getting done so quickly. We are out of witnesses for today.
Ladies and gentlemen of the jury, when you have a trial that lasts several days and you saw the list of potential witnesses and you know you have a lot of witnesses, the way it works is that we schedule witnesses, guess how long they're going to take, and schedule those witnesses so we don't have 50 people waiting to testify. And so today things went quicker than we expected. However, we always try to make sure that we get done by 4:30 every day, so they did go quicker than expected. But as I told you at the start, we always try and get done by 4:30, and it's more likely we would end sooner in a day than we would go past 4:30. Today we have ran out of witnesses, so we are going to recess for the rest of the day.
So this is the end of the day, the 23rd.
I'm going to read to you. You'll be able to go home and go about your normal life. And I'll ask you again to be back in the jury room at 8:45 tomorrow. We'll try and start at 9 o'clock every morning. And this admonishment goes, we will now recess for the evening. You may go about your normal affairs, but you must not discuss this case with anyone, including family members, friends, or your fellow jurors. As I told you at the beginning of the case, your job as jurors is extremely important. Your decision on your verdict is to be based only upon the evidence that you see and hear in the courtroom and the instructions of law that I will give you. Therefore, to remain fair and impartial, you must refrain from doing the following things until you are discharged from service on this case. You must not converse with any person on any subject connected with this case. You must not read or listen to any outside comments or news accounts of this case. You must not discuss among yourselves any subject connected with the trial or form any opinion on this cause until you start your deliberation on the verdict. You must not view or go to the place where the offense was allegedly committed. If you hear or observe anything about this case outside this courtroom, whether inadvertently or otherwise, you must immediately inform me at the beginning of our next session. Do not discuss any of these things with your fellow jurors at any time. All right, and that includes internet and social media too. This admonishment was written well before the onset of all the social media, so it applies to social media too. And so we will adjourn for today, and we will see you tomorrow morning.
All right.
Okay, so as that takes place, let me load the next video. We have the next two videos available to us. So that happened. That was the end of the 23rd. Let's see. I think. Okay, make sure I'm playing the right one in the right order.
We are on the record on 23 CF 170, People versus Timothy Bliefnick. Mr. Bliefnick appears in person and with counsel Ms. Casey Schnock. People appear by Assistant State's Attorney Josh Jones and Laura Keck. We are ready to continue the jury trial. And Mr. Jones or Ms. Keck, are the people ready to proceed?
We are.
And Ms. Schnock, is the defendant ready to proceed?
Yes.
Are there any issues we need to bring up prior to
They're cranking the audio.
the jury coming in?
I don't have anything, Your Honor.
Ms. Schnock?
I have one minor thing that I would like to bring up with the court before we bring in the jury.
You may.
Mr. Jones and Ms. Keck were kind enough to give us the exhibits that they intend to use at trial. Part of the exhibits that I believe are coming in today are with respect to certain court orders that were entered through the parties' divorce. I have no objection to the orders coming in, but I do have a problem with these orders being shown to the jury with certain points being highlighted like this. And it's only drawing attention to certain points of the order. Like I said, if they want to point things out in the order and ask the witness questions about that, but I do have a problem with the jury being highlighted and blown up certain portions of these orders.
All right, Mr. Jones, you wish to be heard?
Judge, the
Yeah.
orders.
Tommy, give me a call right now.
Jury,
I'll take it
as
off the
part
air.
of a demonstrative exhibit, we are certainly allowed to make part of that order larger so it's easier to read. Otherwise, we're going to sit here and read it, try to read it, and the jury may not be able to see it in the order. So absolutely, we are absolutely allowed to blow up parts of those orders. If Ms. Schnock wants to blow up different parts of the order, she has the opportunity to do that. But this is our case, and if there are portions that we think are relevant, we should be and are allowed to highlight them, not just by talking about them, but by showing them to the jury.
Ms. Schnock, you wish to be heard further?
The jury's perfectly capable of reading on their own, Your Honor.
The court believes that if the people first publish the full order that they have entered, then after they have published the entirety of the order, then they are allowed to highlight certain parts either by blowing it up or highlighting it in some other manner. So as long as the people publish the full document first, then they are allowed to make reference to and highlight certain parts of that order. And then
along those lines, Your Honor, would be submissions from Rick Zimmerman's guardian ad litem report. The people have provided me an exhibit which gives me 1 page of his second supplemental report, and I would request that that report come in its entirety. And if the people want to, as you said, make note or highlight, if you will, that 1 page, they certainly can. But in my opinion, it should come in its entirety as opposed to on a page-by-page or piecemeal basis.
Mr. Jones, you wish to be heard on that?
Judge, the entire report will be part of the exhibit. The entire report is part of this exhibit. We don't have to show every page of this divorce file. We can show portions of it that are relevant to our case. Ms. Schnock is free to show anything else she wants, but it's our case, Your Honor. We're allowed to show what parts we think are most relevant and to present them to the jury in a way that makes sense to them. We don't have to show them every page of this divorce file. And that's what Ms. Schnock is asking, that she get to decide how we present our case to the jury. And that's not fair, Your Honor. We're allowed to present the case in the manner we think is appropriate and makes the most sense to the jury.
Ms. Schnock, you wish to be heard?
I'm not asking that the entire file be published to the jury. I'm just asking that the report that the people are going to be relied on be admitted in its entirety. And I think Mr. Jones just said that it would be admitted in its entirety, which is fine. I'm not expecting him to show everybody everything, and that's not even the entire divorce file. But I'm not expecting that he do that. I was simply making a record and making sure that we had a mutual understanding that the entire report would come in, and if they want to highlight certain things, they can. If I want to highlight certain things, I can. But I think it's important that the report come in for completeness, and so that the jury has a basis for the recommendation that the people would be highlighting.
Yes, because of the rule of completeness, the whole report it will be admitted originally, all right, and then after that report is admitted, then either the parties can pick and choose what parts of that report they get to highlight or they want to draw the jury's attention to. So as long as the full report is admitted originally, then that will be used. Then people or the defendant can use any parts of that report. Anything further that we need to discuss?
Not for me, Your Honor, thank you.
Mr. Jones. All right, and what the court's going to try and remember to do before we bring the jury in, once it's 9 o'clock and everybody who wants to be in the trial is here, I will remind and try and admonish the gallery again about cell phones, okay? So unless there's anything else, we will be in recess until 9 o'clock. Okay, good morning. We are on the record with 23 CF 170, People versus Timothy Bliefnick. Mr. Bliefnick appears in person and with counsel, Ms. Casey Schnock. People appear by Assistant State's Attorney Josh Jones and Laura Keck, and we are ready to start today's trial. We are still on the people's case in chief, and for the spectators in the audience, I want to remind you, you are allowed to have cell phones in the courthouse. However, those cell phones must be turned all the way off and must be out of sight while you are in the courtroom. So if you have your cell phone in the courtroom, you must, at this point, turn them off. That excludes media, because media is allowed to have their devices, are allowed to be able to communicate during the trial, but they need to have their badges on, because if you have your device out and you do not have your badge on, then you can expect to be approached by security, because if you have your device out or your device goes off, then security will escort you out and you will not be able to come back in until the next day. So I'm just reminding you all of that, and I believe security will try and remind you throughout the day or at breaks as to that policy with the cell phones. And then after,
so no cell phones,
having said that, Mr. Jones, anything before we bring the jury in?
Nothing for the people.
And Ms. Schnock?
Nothing for us, Your Honor.
All right, let's bring in the jury.
All right.
Okay, jury's coming in. I'm afraid they're going to try to fix this audio, and I've boosted everything. I'm trying to keep it down just in case they try to fix it right at the last minute. And it's going to like jump up in volume. And it's like they switched from a line feed to a mic feed, or vice versa. Judge is in the left ear today. I'm going to see if I can get some more sound in the right ear, but it's not happening right now. It's brutal.
The Assistant Circuit Court is now reconvened. Robert K. Adrian, Judge presiding. You may be seated.
Herd of elephants sat down in the jury box.
Good morning, ladies and gentlemen of the jury. We are ready to continue our trial. We are still on the prosecution's case in chief. And Mr. Jones, do you have evidence today?
I do, Your Honor. People would call Denny Woodworth.
Denny Woodworth.
Your Honor, while Mr. Woodworth is coming in, we would ask the court to take judicial notice of Exhibit 72, which is the court filings in the Bliednick versus Bliefnick divorce case 21
D16. Any objection to the court taking judicial notice of its records in that file?
No, Your Honor.
Court will take judicial notice of those records, and that whole file will be admitted into evidence. And then, wait, are you good there? Okay. Wait, just. Are the jurors okay with being able to see with the court reporter there? Okay, everybody okay? All right, then you do not have to move. All right, Mr. Woodworth, if you'd raise your right hand.
You do solemnly swear that the testimony may give in the cause now pending before this court should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, and if you could come around here and have a seat there.
The judge's microphone volume is turned up so high. Hopefully everything else will be better.
Then scoot up to the table to where you're comfortable, bend that microphone in front of you, and speak towards the microphone, please.
Can you tell me your name?
Dennis Woodworth.
Mr. Woodworth, what do you do for a living?
I'm an attorney with the law firm of Bliednick, Timberlake, and Woodworth.
What kind of law do you practice?
We practice general practice, divorce work, personal injury, DUI, anything that comes in the door with the exception of Social Security disability claims.
How long have you done that?
28 years.
Mr.
Anything
Woodworth,
that comes in the door.
2021, did you begin to represent someone by the name of Rebecca or Becky Bliefnick?
I did.
And what was the nature of that representation? What were you representing her in?
She was served with divorce papers and she was a respondent in the divorce.
When was that divorce filed?
It was filed in January of 2021.
When you began representing Ms. Bliefnick, did you file a temporary order, or was a temporary order entered in that case dealing with temporary custody, child support, maintenance, et cetera, issues like that?
Yes, it was.
Your Honor, that's part of People's Exhibit 72, I believe. It's been admitted into evidence, and we would ask at this point to publish the temporary order filed August 3rd, 2021.
Mr. Jones, I'm going to stop you. Okay. So the court's records in 21D16.
21D16, Your Honor.
Yes. Okay. And that's exhibit number for the record.
So the entire file is Exhibit 72.
Okay. Exhibit 72, and that's been admitted. And then you are making reference to a portion of that, correct?
Correct. Specifically, it's a temporary order entered by the court in that file on August 3rd, 2021.
Okay. And is there any type of are you using any type of letter, like, so that we can have Exhibit 72A?
We cannot do that. We can modify that.
Let's modify that so it makes easy reference to that. So
then, Your Honor, we'll call the temporary order on August 3rd, 2021, Exhibit 72A.
Okay, Exhibit 72A is a temporary order. All right, and that's been admitted as part of the original file. You may proceed.
If we could have that up on the screen.
Exhibit
We have
A.
highlighted some portions of that temporary order 72A. And under A on that temporary order from August 3rd, 2021, that order indicates that Ray Bliefnick shall not have any unsupervised contact with the minor children. Is that correct?
That's correct.
Do you know who Ray Bliefnick is?
That would be Tim Bliefnick's father.
And as long as you were involved in the case, this temporary order remained in effect that the defendant's father would have no unsupervised contact with the minor children.
That is correct.
Under paragraph B of that temporary order, the petitioner, and the petitioner in this case is the defendant, is that right?
That is correct.
And I guess for the record, do you see the petitioner here in court today?
Yes.
Could you point him out, describe what he's wearing?
Mr. Bliefnick is wearing a brown shirt, and sitting at council table on the far east end.
Your Honor, we'd ask the record reflect he's identified the defendant as that petitioner.
The record will reflect that the witness has identified the defendant.
And under paragraph B, the petitioner, the defendant, was to pay maintenance in the amount of $2,150. $100.50. Is that correct?
That is correct.
And as long as you were the attorney in the case, that had not changed.
It did change subsequent thereto. There was a motion to reconsider that changed. Well, the maintenance didn't change. It was a child support amount that changed.
Maintenance amount stayed the same.
Maintenance amount stayed the same, correct.
And in the temporary order of this date, the child support that the petitioner was paying to Becky Bliefnick, the defendant was paying to Becky Bliefnick, was $472. Is that right?
Correct.
So he's paying $2572.50 a month
If you could
to Rebecca between the maintenance and the child support payments. I did the math in my head.
Course of your representation of Ms.
25.
In that divorce, was there discussion about a firearm, specifically a CZ-75 9mm handgun?
There was.
In the course of that divorce, did you make any requests of the defendant and his counsel?
Yes.
And what was that request?
We had filed a petition for the return of that gun to Ms. Bliefnick.
Was that petition granted? Did the court order the defendant to return that gun to Ms. Bliefnick?
The court did.
And was that a order in the court that was also in 21D16?
It was.
Your Honor, we'd ask that that order of injunction from October 22nd, 2021, which is also part of Exhibit 72, be introduced. And again, we have not done this yet, but moving forward we will. This would be Exhibit 72B.
Right. Thank you.
And permission from the court to publish it.
You may publish it.
Is this that order of injunction that we referred to that is dated October 22nd, 2021 and signed by a judge?
Yes, it is.
And Ms. Keck, could you I'm sorry, and there were a couple other things I wanted to cover on this. In that order of injunction, were both parties also ordered that they would not go to the other party's residence except for the exchange of the minor children, that neither party shall enter the home of the other party, nor shall either party have the children go into the home of the other party without specific permission of the party's home that would be entered?
That's correct.
At that time, was Rebecca Bliefnick living at 2528 Kentucky?
The marital home, yes.
And she had been given, awarded at that point, the marital home, not in a final sense, but at that point she was awarded the marital home. Is that right?
She was granted exclusive possession of the home.
At 2528 Kentucky?
Correct.
And the defendant was living at a different location, 1641 Hampshire, is that right?
That's correct.
And according to this order, Ms. Bliefnick could not go into the defendant's home at 1641 Hampshire, and the defendant could not go into her home at 2528 Kentucky.
That's correct. That's correct.
Under paragraph 12 of that temporary order, Exhibit 72B, the petitioner shall turn over to the respondent the 9mm handgun, CZ-75B, as soon as she purchases a safe for the same and provides to the petitioner a receipt of said purchase. That in the event the petitioner cannot locate the 9mm handgun, CZ-75B, then he shall turn over a 9mm Ruger 9CLS handgun to the respondent during the pendency of this cause of action. Is that correct?
That is correct.
So Rebecca gets a 9mm one way or another. That's what that statement says. She gets a 9mm handgun. Either a CZ or a Ruger. Jacka, we're going into the divorce proceedings. between the victim and the
Was
defendant.
that firearm or any firearm ever provided to her?
No.
During the course of your representation of Becky Bliefnick, did she ever provide documentation to you that she had purchased a gun safe?
She went out and immediately purchased a gun safe.
Did you speak with Ms. Bliefnick about why she wanted that gun?
I did.
What did she say about why she wanted that firearm?
She wanted it for protection.
Protection from who?
Her husband, Tim Bliefnick.
The defendant?
Yes.
Mr. Woodworth, in the 28 years that you've practiced law, how many divorce cases have you handled?
50 to 100 divorces a year.
Fair to say 2,000 to 3,000 divorces in your career then?
Yes.
In Adams County?
All surrounding counties.
Brown County?
Brown County.
Calhoun?
Not Calhoun.
Okay. In those nearly 3,000 divorces that you've handled, have you had clients say they were scared of the other side of the divorce?
Objection, Your Honor. Anything any of his other clients would have told him would be inherently
That will be
hearsay.
sustained.
The defense has said that this is just divorce talk.
I haven't said anything yet.
It'll be sustained, Mr. Jones. Ask a different question.
In those 2,000 to 3,000 divorces that you've handled, have you ever had a client murdered before?
No.
That's all the questions I have.
Cross, Ms. Schnapp.
Thank you. Good morning, Mr. Woodward.
Good morning.
I want to start by talking about the order that was entered on August 3rd, 2021.
Okay.
Was this an agreed upon order or was this an order by the court?
Was this the order that was on the screen previously?
Yes, it would be People's Exhibit 72A.
I may have that with me if I can look at that, unless you want to put it back up on.
If you want, if Mr. Jones wants to.
Put it back up on the screen if we could.
I believe a new video just dropped on Matthew Harris's channel, so great thing to watch on lunch.
I would need to see the entire order, the introductory.
The entire order's in the file.
Okay. And the date is August.
The date of the order is August 3rd, 2020.
Okay. I've got a copy of that with me.
All right.
Defense attorney's a little spicy. She shows some emotion.
That was a hearing that we had.
Okay, so that would have been a court order and not an agreed upon order, correct?
Yep.
Okay, and as part of that order by the court was an order for temporary maintenance, correct?
Correct.
Okay,
Yep.
and the duration of maintenance in the state of Illinois is dictated by statute, correct?
Correct.
And the duration of maintenance is largely in part dictated by the length of the marriage, correct?
Correct.
And there are certain tables, if you will, that dictate multipliers, if you will, that dictate how long maintenance should be paid depending on the length of the marriage, correct?
Correct. Correct.
Maintenance can be made retroactive, correct?
Correct.
So if there were to be a permanent order of maintenance ordered in any case, that person would get credit for any temporary payments made under the temporary order, correct?
Absolutely.
Okay. And so Tim would have gotten credit for all of the maintenance payments going back to August 1st of 2021, correct?
Anything that he paid, yes.
Okay. And he would not be required to pay maintenance above and beyond what the statutory guidelines say, correct?
Unless the court ordered otherwise, correct.
And so, Your Honor, may I approach?
You may.
I am handing up what I have marked as Defense Exhibit 1. And you're familiar, and you said that you were familiar with the multiplier tables with respect to maintenance and your involvement in practicing law, correct?
Correct.
And I'm handing up Defense Exhibit 1 for identification, Mr. Woodworth, and if you could take your time looking at these tables and let me know when you've had sufficient time to look at this.
Yes, this is a multiplier table.
Okay, and these are accurate and in line with the law today, correct?
Yes.
Okay, so a marriage of 10 years has a multiplier of 0.44, correct?
Correct.
And a marriage of 11 years has a multiplier of 0.48, correct?
Correct.
And the parties in this matter were married in September of 2009, correct?
I do not have a copy of the petition for dissolution of marriage was filed, so I don't know the actual date of the marriage. If you got a copy of that, I can.
People will stipulate that the marriage occurred in 2009.
Okay.
Okay.
And then the time period would have been told when the divorce was filed in January of 2021, correct?
When you mean told, what do you?
The duration of the marriage would be determined from the date of the marriage until the time of filing.
Well, the time of divorce.
Time of divorce.
Time the divorce is granted is duration.
And so that would determine the length of the marriage, which would determine the length of time that maintenance should have to be paid, correct?
Correct.
Okay. Yep. And like you said, that number can vary if the court thinks it's appropriate, correct?
Correct.
Courts don't always deviate from the statutory guidelines, do they?
They don't always know.
And not only can the court deviate from the guidelines with respect to the duration of maintenance, but they can also deviate from the guidelines with respect to the amount of maintenance, correct?
Correct.
And in any divorce, maintenance is not a guarantee to anybody, correct?
Correct.
There are certain statutory factors that need to be considered by a court and by the attorneys and by the parties in order to determine if a person is even an appropriate candidate for maintenance, correct?
That is correct.
And one of the first things that you need to look at is whether or not there is a demonstrated need for maintenance, correct?
That is correct.
So if somebody does not have a need for maintenance, it is unlikely that a court could order maintenance, correct?
That is a very good possibility.
And on the other hand, if somebody does not have the ability to pay maintenance, a court could possibly say you do not have to pay maintenance, correct?
Or could deviate from the.
Yeah, could deviate down depending on the circumstances,
That is correct.
Okay. During your, and the same thing with child support can be made retroactive as well, correct?
Correct.
And in this matter, Tim would have gotten credit for all child support payments that would have been made effective August 12th of 2021, correct?
Correct, yeah.
So whether the divorce went on for a year after that, or 2 years after that, or however long after that, though there would still be credit given where credit was due, correct?
Correct.
Okay. When did your involvement in the divorce terminate?
I believe it was in November, around November of 2021.
Okay. And is that when you handed this case off to your partner, Mr. Timmerwolke?
Yes, correct.
All right. During your involvement from April 2021 to November of 2021, did you ever file a petition alleging that Mr. Bliefnick had not paid maintenance?
Without looking at the file, that was 2 years ago. I'd have to look at the file to see if I had filed a petition for contempt or something to that effect. That would have been the petition that I would have filed if that.
Absolutely. And when somebody doesn't follow a court order in divorce court, then the remedy is to file a petition to show cause, correct?
That's correct.
And that is to bring to the court's attention somebody's failure to follow a court order, correct?
That's correct.
And in that event, the court could order sanctions and enter an arrearage on the unpaid balance, correct?
Good, yes.
All right. Would looking through your file sufficiently refresh your recollection as to whether or not you did that?
It would if I had the entire file.
Surely if Becky came to you with complaints that maintenance wasn't being paid, you would have filed such petition, correct?
Oh, absolutely.
Okay. And if Becky came to you with complaints that Tim was not paying child support, certainly you would have filed a petition to show cause, correct?
I would have.
And if Tim had not been making the mortgage payments as he was ordered, then certainly you would have filed a petition to show cause with respect to that, correct?
I would have. The only way I wouldn't have is if, and a lot of times in our practice, what we do is we send the other attorney a letter first saying, hey, your client isn't doing this. Please address this before we have to file contempt. So that would have been the only other way that situation would have been brought to the attention.
And as you're sitting here today, do you have...
I'm going to just stop you.
Okay.
The court has the docket sheet from the file, Exhibit 72, which has been admitted. Mr. Woodworth, if I hand you that docket sheet, would you be able to look through that to see if, in fact, there was a petition filed?
I can certainly look at it. Just
Any
7 pages long, I know.
to allowing
Judge just
the
volunteered
witness
some
to
stuff.
look through the docket sheet of that file?
No, Your Honor.
Ms. Schnock?
No.
That was the judge on his own volition. Says, "Oh, I found some records that might help the witness out." You guys cool if I just interrupt the questioning and hand over these documents? They're both cool with it, so there's no problem. There's no issue of mistrial there. I've just never seen the judge do some homework on his own. He's like, "Hey guys, I found it. It's right here. I've got the document." Oh, good stuff. I do apologize. Hopefully, it's just this video, which is about 25% over, that has the audio issues. Somewhere along the audio chain, someone has turned the volume all the way up past 11, and it's clipping the top end off, and then they've reduced it somewhere else. So even though the decibels are in the normal hearing range, it sounds like we're listening to it much louder than normal.
And Mr. Woodworth, while you're looking through that
it's awful.
file, I have the file pulled up, so if you see something that could be a question, then
Just
I can show that to you.
Any
on
other
the
documents you want
computer.
from any other trial, I have everything on my computer, and I could just print them off. Illinois is a little different. We're learning that. This is an interesting trial, especially the
There was a
time
motion for indirect civil contempt of court filed on July 21st of 2021, but the docket sheet doesn't say what that particular issue was.
Sure, Judge, print that one off.
was raised
See
in
what
that
that is.
contempt petition.
Mr. Woodworth, I have that actually pulled up on the computer. Mr. Jones and Ms. Schnock, if you want to
Approach.
come and look at that.
This is crazy. We don't know why the defendant's dad was court ordered not to be able to see the kids. I'm not sure what the reasoning was.
That would not be relevant for
I'm looking at a different one than I think she's picked up. Ms. Schnock, you can scroll down.
Each state is different. They are.
Scroll.
He stands up behind the judge, literally looking over his shoulder on his desk. Man, the DA is tall. He's like towering over everybody else. I'm not sure if the others. I mean, the judge is bent over. Maybe but he's got at least a foot on, or 6-8 inches over the judge for sure. Look at the button up. 1, 2, 3, 4, 5. 5 buttons. While they're doing this, let me just say, my son has a friend who calls to speak to my son. And if anyone answers other than my son, he hangs up the phone. And then he calls back again. So I get a lot of calls. And when you answer, the DA is a giant. Lurch is lurching.
Wait, go
Go.
to the microphone.
Go.
All right. The record should reflect that the court has pulled up a document which is entitled Petition to Find Petitioner in Indirect Civil Contempt of Court. That was filed on July 21st, 2021. It is a 4-count, it's a 5-count petition. Both the, it's actually a 6-count petition. Both the prosecution and defense has had a chance to review that. Based on that, Ms. Schnock, you may proceed.
Thank you. Was there ever a judgment, in your involvement in the case, was there ever a judgment entered on any arrearage with respect to maintenance or child support?
Not that I recall.
Okay. Also, as part of, I believe, that temporary, let me pull that up real quick.
So I'm not sure if the witness got to see that or not. So he was held in contempt, but not
During
for
your
not
involvement with the parties' divorce, were they ordered to communicate through the Our Family Wizard app?
Yes.
And is that an app that's commonly used in divorce proceedings to keep people honest with their communications?
It is, to keep a record of what is said between the parties.
Yeah. So if somebody says something in poor form, there's a record of it, correct?
There is.
And that's to protect both parties, correct?
Correct.
Okay. And that was done in this matter, correct?
Correct.
Okay. Mr. Woodworth, moving on to the order that was entered on October 22nd of 2001. This would be the order of injunction. I believe it's People's Exhibit number 72B.
And was that dated October 22nd, 2021?
Yes, sir.
Okay.
And paragraph 12 is the provision of that order that deals with the return of the 9mm CZ, correct?
Correct.
And the third line of paragraph 12 contemplates an event where the petitioner in that matter, being Tim Bliefnick, cannot locate the 9mm handgun. So when that order was entered, is it correct that it was contemplated that it was a possibility that that could not be located?
There was. Mr. Bliefnick's attorney had made the statement that he may not be able to find that handgun.
Okay, and that was back in, going back to at least October 22nd of 2021, correct?
That is correct.
And did Becky provide you a receipt of the purchase of that, of the gun safe?
Yes.
Okay, and do you recall when she provided you the receipt of that gun safe?
It was very quickly after the order was entered.
Okay, and did you turn that over to Mr. Bliefnick's attorney at the time?
Yes.
Okay. You stated to Mr. Jones that Becky told you that she wanted that gun for protection, correct?
That is correct.
Okay. During the course of your involvement in Becky's representation, did you ever file a petition to show cause to return the handgun?
In looking at the docket sheet, I don't believe I did unless the contempt petition had to deal with that. And I think that was I think that petition predated the order entered.
Okay. And had Becky came to you and said, will you do something about getting this gun back to me, certainly you would have done that, correct?
Oh, I'm sure it would have, yes.
Okay. The same thing with any other protective orders. If a client comes to you and says, I'm scared, I need you to do something for me, you would do that, correct?
Yes, if it's within the law, yes.
Sure. And also along the divorce lines, there was discovery that you were involved in from April through November of 2021, correct?
Massive amounts of discovery in this case.
And during the course of discovery, did Becky ever show you any pictures of any bruising or marks on her purporting to be made by Tim?
She had complained of some of his, I guess, episodes, she would call them. But as far as showing me the actual picture, no.
Okay, and there was nothing that you filed on her behalf as far as any restrictions or anything like that?
I did not, because these parties, early on in the case, a petition for exclusive possession of the marital home was filed and granted. So Ms. Bliefnick stayed in the marital home. Mr. Bliefnick went and got a residence of his own. So they were separated from the beginning of this divorce proceeding, or pretty much from the beginning.
Okay, and at the time you got involved in the divorce, had they already separated physically?
They had separated physically.
Okay, and was it during your involvement in the divorce that exclusive possession was granted?
Correct.
Okay, and once exclusive possession, oh, strike that. Do you recall when that was done? It would have been done through that temporary order,
The
correct?
temporary order that was referred to earlier, I think, was July, I believe.
Okay. Do you remember when, during the course of your representation, Becky would have made that statement to you with respect to the gun?
Well, it would have been when we filed the motion. There was a motion filed concerning that gun.
Okay.
So it would have been shortly before that motion was filed.
Okay. And if Becky would have came to you with requests that could have been filed within the law, you would have done that for her?
Correct. Yeah.
No other questions, Judge?
Before you get started, Mr. Woodworth, I want you to explain one thing. You talked about the multiplier when it comes
Judge is asking a question.
to maintenance, or which used to be called alimony, and I don't believe lay people understand what that multiplier is or how is it used. Could you just explain that for them, please?
Yes. For example, if it's a 10-year marriage and the multiplier is 0.44, you take 10 years times that 0.44, and that determines the length of the maintenance. So in that case, it'd be 4 years and 4 months. So.
Thank you. Go ahead, Mr. Jones.
Thank you, Your Honor. Just a few questions on recross and redirect, and I'll start with what the judges referred to, the alimony calculations. The maintenance or alimony calculations are not set in stone. It's not like you can go to put it in a computer program and find out exactly what it's going to be. Is that fair to say?
You can put it in the program, but ultimately the court is the decision maker when it comes to setting the amount of the maintenance.
And the court would hear evidence in a hearing like that to determine what the alimony would be.
Yeah, typically what happens is the attorneys on both sides prepare maintenance or child support calculations. Those are presented as exhibits to the court. The court can do its own calculations, however, if there's objections to one of the calculations or both of the calculations. So it can be input from both parties' attorneys and or the court's calculation.
And can the court hear evidence on that from witnesses?
Certainly can.
The petitioner could present evidence?
Correct.
The respondent could present evidence?
Correct.
But not if the respondent's dead.
Correct.
The respondent can't present evidence if she's dead.
Correct.
But not if she's dead.
And that amount of alimony can deviate up or down depending on what evidence the court may or may not be able to hear, correct?
Oh, absolutely. Depending on the income of the parties, it can go up or down.
Are there other issues that might affect whether or not that alimony amount is deviated up or down?
Yeah, the statute has several different factors the court can look at when deciding whether to deviate up or down. As Ms. Snock said, the need of a party is one of the biggest factors, and the other party's ability to pay. So when you have a situation where a person is making substantial income, and when I say that, over $250,000 per year, and you have another party that may be making $30,000 per year, the amount may be a certain dollar figure, but the court can deviate up based upon the ability to pay. And the other substantial factor the court considers is the lifestyle the children would have enjoyed during the course of the marriage. So the court's got to take all those statutory factors into account.
You told us one of those statutory factors is the respective incomes of the parties. Is that right?
Correct.
When you were involved in this case, were you aware of the respective incomes of the defendant and Becky Bliefnick?
Yes.
With regard to their relative incomes, was one of them making substantially more than the other?
Yes.
And who was making substantially more than the other?
Mr. Bliefnick was.
The defendant?
Yes.
Ms. Schnock asked you whether or not you had ever filed any petitions in this case. Remember that question?
Yes.
And the court showed you a petition from July 21st, 2021. Is
Okay.
that right? Would it refresh your recollection if you were able to see that petition from the court?
Sure. Yeah.
Your Honor, I'd ask that the court allow Mr. Woodworth to look at that petition from July 21st, 2021.
All right. Mr.
So the
Woodworth, if you could stand up, please, because I can't move the screen.
I just come up,
if you
sit in my chair for a while, look at my computer. This is crazy. This is they've called it the Family Feud trial, but really the defendant was on Family Feud years ago, and he said something not very complimentary about marriage as one of his answers. And now he's on trial for the murder of his wife, who he was in the process of getting divorced from.
Mr. Woodworth.
So this is the attorney we're listening to right now, Mr. Woodworth, the attorney for the wife in the divorce case. And so a lot of information from the divorce is coming in right now. Apparently the defendant was making a lot more money than the wife was. The defendant had to pay about $2,550 a month in mostly maintenance and a little bit of, so that was the alimony side. A little bit of child support, a few hundred in child support for 3 kids. They had 3 sons together. The wife did have the marital home. That was all hers. He had to go live somewhere else. Also in this, we haven't heard an explanation on it, but the defendant's dad was not allowed to be around the kids. So we don't know what that's going to play in. We do know that right before the murders, the defendant did go get a Little Tikes basketball hoop, which is a brand of little plastic play toys, and dropped that off at his dad's house. And I think they're insinuating that that the kids were going to be over there playing soon. So very, very interesting. Yeah, his response on the game show on the Family Feud was saying "I do" was his biggest mistake at his wedding, or that was the answer that he thinks would be on the board. So saying "I do" was a mistake. Sounds like they had a less than ideal marriage. Did last for a while, 10 years, 3 kids. That's why we get the multiplier of 0.4 for how long he has to pay that amount. And because this is Illinois under the safety law, they are moving very quickly. This murder only happened on February 23rd of this year, and we're already in trial here in the latter part of May. So it's very quick. You'll see that most apparently is in the testimony of witnesses who are family members who are still, this is very, very raw. I mean, even years down the road, it's very difficult to testify about a loved one's death. We've seen that in other trials as well. But this is just, there's a good chance the grave doesn't have a headstone yet. I mean, it's that close to the time frame between the murder and the trial.
The record should reflect that the court had pulled up the petition on its computer screen. The court has allowed the witness to review that petition. And Mr. Woodworth, is there any further parts of that petition you'd like to view before we proceed?
No.
All right. You may proceed, Mr. Jones.
Mr. Woodworth, you had in fact filed a petition to show cause against the defendant in this case. Is that right?
Correct.
And one of the allegations in that petition was failure to pay the alimony as ordered by the court. Is that correct?
Correct.
That's all the questions I have.
So his recollection has
Mr.
been
Knock, I'm going
refreshed
to
by
give you a
looking at the
chance to
records.
recross if you want.
Thank you. The court you never pressed the issue with the court with respect to that petition to show cause, correct?
That could be correct. I don't have the entire file anymore because it got subpoenaed.
We'll stipulate that there was no hearing on
There was no the people will stipulate that there was no hearing on that request of the court. Okay.
Okay.
When Mr. Jones was asking you about the income of the parties and setting maintenance. You said that the parties can fight over that, correct?
Absolutely.
And they can present their own evidence with respect to what they think their income is and what they think their spouse's income is, correct?
Correct.
And part of that would include a provision of the law regarding imputing income to a party, correct?
It could.
Okay, so if a party has the ability to make more money than what they are actually making, a judge could use a different number in calculating maintenance and child support if they believe that party has the ability to make more than they're reporting, correct?
Yeah, if a judge believes that somebody is, I'm going to call it underemployed, that could potentially happen.
Sure. And if there's a record of somebody making, let's say, $10,000 a month for several months, and all of a sudden it goes down to $5,000 a month, that could be grounds for an attorney to say we want to impute income to this person because they have the ability to make $10,000 a month, as they have shown us over the course of however much time.
It could happen, yeah.
Okay. So just because an attorney prepares a calculation and puts certain numbers into a computer program does not mean that a judge has to accept it. Is that fair?
That's correct.
And sometimes as divorce attorneys, do we use numbers to our client's own advantage within the bounds of the law?
Yes.
Okay, so if it may not be uncommon to reduce somebody's income within the bounds of the law for purposes of making these calculations.
True.
I think a common practice would be not including bonuses as part of income, correct?
That could happen. Somebody can use a calculation not including bonuses, and the other side could use a calculation including that bonus.
Okay, and so when we as attorneys provide these proposed calculations to the court, sometimes it's a wish. Is that fair? We don't necessarily expect to get that sometimes. Is that fair?
That's correct.
And we do the best that we can to advocate for our clients within the bounds of the law. Is that fair?
Correct.
Okay, and that doesn't mean that you have to accept the other side's numbers or the other side's position, correct?
And the court doesn't either.
Yeah, and that's just part of being and working in divorce court. Is that fair?
Correct.
This lawyer,
no other questions?
The defense lawyer was also representing the defendant in the divorce law.
Yes.
Divorce case.
There was never a final divorce hearing in this case, was there?
There was not.
And that's because Becky Bliefnick was murdered.
Correct.
That's all the questions I have.
All right, you may step down if you could.
So those two lawyers were going at each other in court before, in divorce court. That's why it seemed a little hostile there. They've fought before at other hearings. That lawyer saying, "Hey, I don't remember because my case was subpoenaed. You guys took all my records because your client murdered my client."
Mr. Jones, may call your next witness.
Timothy was
One of the people would call Sarah Murphy.
Sarah Murphy. Sarah Murphy's going to be coming up to the stand. I'm not sure if we're going to be able to see her or not. I've only been able to see a few. I think the judge is allowing people to decide whether or not they want to appear on camera. And most of the, yep, this is a not, I think. Most of these are no's.
Ma'am, if you could step up to the front of the courtroom. Right. Come on up a little closer. Raise your right hand. Be sworn by the clerk.
You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, if you'll come around here and have a seat right here in this chair. Kind of scoot up to the table to where you're comfortable, and then you can bend that microphone so it's in front of you, and please speak towards the microphone, okay? All right, you may inquire.
Thank you, Your Honor. Could you tell us your name, please?
Sarah Murphy.
Ms. Murphy, how are you employed?
I work at Blessing Hospital.
What do you do at Blessing Hospital?
I'm a nurse on the vascular access team.
I'm gonna ask you to slow down just a little bit, okay?
Okay, sorry.
I'm gonna start talking really fast. When you say vascular access team, tell us just generally what is that?
So our team, we place peripheral IVs, midlines, and PICC lines in the patient population, IVs and fancy IVs.
Something I can do. When you say your team, how many people are a part of your team?
We have 4 RN positions.
So it's 4 separate nurses.
Yes.
And do you have a specific spot in the hospital where you work at when you're not with a patient?
We cover the whole house, so we go from unit to unit, but we do have an office in the radiology department.
In that office, do all 4 of the nurses that work with your team work in that office?
Yes.
When we say an office, is it multiple cubicles? Is it multiple rooms? What is it?
Currently we have 2 rooms, but our desks are all in one room. Our other room is a procedure room.
So pretty close quarters, fair to say.
Very close quarters.
Was one of the nurses that works in the vascular access team, you call it VAT team, right?
VAT,
The
yes.
VAT team with you, Becky Bliefnick.
Yes.
When did Becky Bliefnick start working with you in that team?
May of last year.
So May of 2022?
2022, yes.
How often would you work with Becky?
In the beginning, very frequently, and then this last year, she and I worked every Friday and every other weekend together.
Since you were working with Becky in these close quarters, would you talk a lot?
All the time.
Because one of the things you talked about regularly was her divorce.
Yes.
And would you talk about her feelings and thoughts about that divorce?
Yes.
Were you aware of who the person was that she was trying to divorce from?
Yes.
Who was that?
Tim.
Is that how you knew him from her, Tim?
Yes.
During the course of these conversations, did you have discussions about the defendant's father?
Yes.
How did she refer to him?
Ray.
As Ray. What did she tell you was her thoughts about the defendant's father, about Ray, what she wanted to happen?
That she did not want the boys to be alone with Ray.
When you say the boys, her sons?
Her sons, yes.
Did you also talk at one time about something potentially happening to her?
Yes.
And fair to say, were you kind of, you yourself, when you started this conversation, kind of joking around?
Yes.
Tell us how it started.
Usually my husband and I would have had a little argument, and I would tell her how angry, not angry, but, you know, mad I was. So we'd be joking around like, oh, I should just get rid of him, or something to that. I thought we were joking. I was joking. And she would always say if something ever happened to her, that we should make sure we look at Tim.
Looking back, do you wish that you would have taken that a little more seriously?
Yes.
Did you also have recent conversations in 2023 before she was murdered about her upcoming divorce hearing?
Yes.
Do you want a minute?
Nope, I'm good.
Okay. Did she tell you that she was ready for that divorce hearing?
She was very excited.
What did she tell you specifically about that upcoming hearing?
Objection. Anything that Rebecca said would be hearsay with respect to what was coming on at the hearing. We've had.
Okay. That will be sustained. There are certain, and the court would note, there is objection made pre-trial as to hearsay statements that the witness can, this witness and other witnesses can testify to. The court takes this as a renewal of those, of that objection. The court overrules those objections, but the court does not believe that the statements that she is about to make, which are hearsay, were part of that hearing. So the court is going to sustain that part of the objection.
Thank you, Your Honor. When you were talking with Becky in 2023, did she also tell you about a statement that Tim had made to her about the upcoming hearing or about their divorce proceedings?
We talked about it a lot.
Was there a statement that he made about playing games?
Yeah.
Can you tell us what that was?
One of the last conversations I remember having with Becky, she was reading me a message, and the only thing that stuck with me is Becky said, he said she was tired of...
Counsel, we can, ma'am, if you'll stay there. We're going to...
They killed the mics. Maybe they can fix them when we come back. I've been playing with everything, trying to get a limiter on there. The audio is blown out. Oh, wow. Field trip. They all went on a field trip. They just walked out of the room. I think they were coming back. This has been cut out, so field trip's over. We're now back here. Please have better audio. Please. I don't think we do.
Right. The objection was sustained in part and overruled in part, and Ms. Keck, you may proceed.
Thank you, Your Honor. Ms. Murphy, we were talking about one of the last conversations that you had with Becky. Can you tell us, was that in January or February of 2023?
It was during basketball season, so I believe January.
And during that conversation, Becky told you something that she said Tim had told her, correct? And in fact,
Is that yes?
Yes, sorry.
And did she tell you that the defendant Tim had told her he was, quote, according to Becky, tired of playing your stupid little games?
Yes.
No other questions, Your Honor.
Ms. Schnock.
Thank you. Good morning, Ms. Murphy. I have some questions that I'm going to ask of you. If you don't hear me, which I don't think will be a problem, or if you don't understand me, will you just let me know? Thank you.
Yes.
Okay. Your association with Becky is through work, correct?
Yes.
Okay. Were you friends outside of work with Becky?
Not as in we hung out all the time. We talked frequently.
Okay, so you talked frequently but didn't necessarily hang out socially. Is that fair?
Yes.
Okay, and you and Becky and all of the other individuals with the VAT team, your desks are in somewhat close quarters, correct?
Yes.
And when you have, 3, 4, 5 women working in close quarters, there's chatter.
Correct.
Girl talk. I think you referenced it when Ms. Keck was questioning you, that sometimes you would come to work and you and your husband would have had a fight and you'd vent there. And Becky would come to work and vent to you about the divorce, correct?
Yes.
And when you were having these conversations, it was in a joking manner. Is that fair?
Yes.
Yes, okay. And so when you were having these conversations, there were never any red flags that went up in your mind with Becky, correct?
No.
Because in your mind these were joking.
Yes.
Things that were said in jest. Is that fair?
Yes.
Okay.
I'm trying to fix the audio as best I can about limiters.
You do not know Tim, is that fair?
Yes.
Have you ever met Tim?
It's blown out in
You
the
do not
courtroom.
know him from anybody else in this courtroom as far as that is concerned, correct?
Correct.
Okay. Did you never called the police on Becky's behalf, correct?
No.
Okay, and you never called Quinata or any other domestic violence assistance on Becky's behalf, correct?
No.
Okay. And there was, at least as far as you're concerned, there was nothing that she told you that caused you any concerns in your mind for her safety?
Physically, no.
Okay. No other questions, Judge?
Ms. Keck?
Thank you, Your Honor. Ms. Murphy, when you were talking, you were joking, correct?
Correct.
You don't know what Becky's thoughts were.
You don't.
That will be overruled. She can answer that.
You don't know what Becky's thoughts were.
I don't.
No other questions, Your Honor.
Ms. Stock, I'll give you another opportunity.
When these conversations were had, they were not serious, correct?
on my behalf. I was joking.
Okay, that's fair. And you wouldn't joke about something like domestic violence if it was a serious situation. Is that also fair?
Correct, I would not.
No other questions?
Ms. Keck?
No, Your Honor, thank you.
All right, you may step down. And is she excused from her subpoena?
Yes, Your Honor.
She can be released from ours as well, Your Honor.
All right, you're free to go or stay, however you wish. All right?
Okay, this is fun. She's sitting and standing. Apparently, they can do whatever they want and can wander around the courtroom.
Judge, can we approach very briefly? You may.
We're going to approach. Mics are killed. Rest our ears. Isn't that beautiful? Sounds amazing. So yeah, this is a fun one. It's getting a little bit spicy. We might have lunch or something here soon. No, I think we're halfway through this video. This is the second video.
All right, ladies and gentlemen, because the next witness may take a while, this would be a good time to take our morning break. So we are going to take our morning recess. You will be given 20 minutes so you're able to refresh yourself, and we will be back in the courtroom at approximately 20 after. All rise.
The elephants stampede out of the room. Chairs are toppled. Desks are shoved aside as the jurors jockey for position to be first in line for the candy machine. I wish you could see what I can see right now in my head as to what is causing all this noise. But it is such a loud courtroom. This is so bad. Let's see. The judge's soul just left his body, I think we're back. Break's over. Elephants come back in.
The jury has left the courtroom. Mr. Jones, Mr. Timberwolke's next. Do you have another witness after that for this morning?
I do, and actually I'm going to speak with Ms. Schnock and Ms. Keck, and we may do... We may call Rick Zimmerman first because I think he'll be shorter, and then Jerry may take up the rest of the morning. But we have another witness on board too if Jerry takes shorter. So.
Okay. All right, then we will be in recess till 20 after. All right.
Just realized this is yesterday's video. This is the second video we've watched today. So we watched the beginning of the end of the 23rd. This is the beginning of the 24th. I believe we have one more video, but this one, I just want to see if they've cut out the break or not. I might have to skip ahead because I can do that. We're trying to catch up at the same time. They're very slow. Yes, I'm not sure if he said Timberwalkie or Jabberwocky. I heard one or the other. Yep, I think we're done. I didn't have to skip it all.
We are back on the record on 23 CF 170, People versus Timothy Bliefnick. Mr. Bliefnick is present in court along with his attorney, Ms. Casey Schnock. People appear by Assistant State's Attorney Josh Jones and Laura Keck. And we are ready to continue with evidence. Mr. Jones, are the people ready? Or Ms. Keck? Ms. Keck, are the people ready?
Yeah.
And Ms. Schnock, is defense ready?
Yes.
All right, then let's bring in the jury.
Bring the jury. Jury's coming in. He's back in black. We're good to go. Yes, the problem we're hearing with the clicking, it's on the defense side. The defense attorney or assistant attorney, I don't know who she is, paralegal. I guess she's probably an attorney seated there at the stand, at the desk. She is typing on her keyboard, and I think she probably has fingernails, which is, most people do. But her microphone, the microphone is right over the computer, and so the sound is just bouncing up from all her typing, which the keyboard is making little clicking noises, and that's what we get. So apparently she's keeping verbatim notes. She doesn't think the court reporter's transcript is enough because she's keeping every word on her laptop with the mechanical keyboard. Yes. Shirt looks good on me. This is a Matthew Harris shirt. He said this to me. It says, everything I know about law, I learned from Matthew Harris Law. I think you can get one of these shirts on his channel, which is a good day to do it because he just released a new video today. I think, I need to go over and just verify that I'm not leading you astray. But I'm pretty sure he just dropped a new video right at lunchtime, about an hour ago.
Now reconvene. You may be seated.
We are ready to continue with the people's case in chief. And Ms. Keck, do you have a witness?
New video.
I do, Your Honor. The people would call Gerald Timmerwolke.
It's about being denied boarding on a plane and how much you get paid. So this is one you all want to watch for sure. So just keep that in your playlist to watch this today. Mr. Wookie. We're also 9 people away from reaching 22,000 subscribers here on this channel. I think it might happen today. 9 people. Invite a couple friends. If you've been lurking and not subscribing all this while, now's a great thing to do it.
Mr. Timmerwolke, if you'll step to the front of the courtroom, raise your right hand and be sworn.
You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, and help you God?
I do. Come over here and have a seat, Mr. Timmerwolke. And as you know, scoot up to the table and put the microphone in front of you and speak towards the microphone.
Very good.
You may inquire.
Can you tell us your name, please?
Jerry Timmerwolke.
Mr. Timmerwolke, Mr. Jones asked, can you spell your first and last name for us?
It's actually Gerald, Gerald, Timmerwilke.
Thank you.
I would have missed that one.
How are you employed?
I'm an attorney.
How long have you been an attorney?
46 years.
What types of law do you practice?
General practice, family law, criminal law, civil suits, personal injury cases, workers' comp.
Anything that comes to the door.
Is one of the people that you work with in your firm, Denny Woodworth?
Yes.
In late 2021, did you take over a divorce case from Mr. Woodworth?
Yes, I took over in November of 2021.
Was that a divorce case involving Tim and Becky Bliefnick?
Yes.
And do you see Tim Bliefnick here in the courtroom today?
I do.
Can you tell us where he's sitting and what he's wearing?
He's at the last chair at the console table, and he has, it looks like a brown top on.
Your Honor, the record reflect that Mr. Timmerwolke has identified the defendant.
The record will reflect if the witness has identified the defendant.
Mr. Timmerwolke, when you took over that divorce, I assume you reviewed all of the filings?
Yes.
Did you continue then to represent Becky until February 2023?
Yes.
During that time that you represented Becky in that divorce, was that an easy divorce, or how would you characterize it?
Very contested.
Were they fighting over everything?
Yes, they were fighting over mostly the children, the 3 boys. They were fighting over an issue concerning the defendant's father and his supervised or unsupervised visits with the grandchildren, property division, debt division, and maintenance and child support.
I want to talk to you about a little bit about those. You said they were fighting over the children. What were they fighting about with regards to the children?
When the case started out, my history of the case was that Becky was the primary parent for a number of years. She didn't work. When they had the children, it was by agreement. Mr. Bliefnick made good money, and she was a stay-at-home mother. That kind of changed. She became interested in nursing around 2016, and she started working as a part-time nurse. So by the time the divorce came, she was still the primary parent. When the divorce started out, it would have been, I'll use this, the old way, where maybe he was going to get weekends and have a weeknight. But as times progressed, the situation was that it became a 50-50, and that was through, actually, Judge Adrian had the case at that time.
While that divorce was proceeding, was there an order entered on August 30th, 2022 with regards to how the children would be exchanged?
I believe that they were to be exchanged at the house, but there was not to be entry into the house.
Was there also a provision about that they had to stay within 3 feet of their vehicle when they...
Yes. Yes.
Fixing the audio.
So not only could Becky not go into Tim's house, Tim couldn't go into Becky's house, they were supposed to stay within 3 feet of their vehicle at that time.
Yes, that's what the judge ordered.
And that court order was still in effect when Becky was killed on February 23rd, 2023.
That's correct.
During the divorce, in December of 2022, you were getting closer to a final hearing, is that correct?
Yes.
As divorces get close to a final hearing, is one of the things that you do is each party files what's called a pretrial affidavit.
That's correct. It's under local rule, and it has a number of items that you need to put in it: general information, property division, debt division, matters concerning the children, and it's all laid out with exhibits. It's the primary, I guess, document that the courts look at to determine the case.
When you are putting those proposals together, does each side put in that pretrial affidavit their proposals about what they want the court to do?
Correct.
Did you file a pretrial affidavit on Becky's behalf?
I did.
Was that filed on December 16th, 2022?
Yes.
When you filed that, one of the things that was contested during the divorce was a handgun that was a CZ75, is that right?
That is correct.
That handgun had actually been ordered to be returned to Becky before you even entered in 2020, correct?
That's correct. It was either done in July or August. I can't remember which order off the top of my head.
When you took over in November 2021, Becky still didn't have that handgun back.
She did not.
Did she have that handgun back when you filed the pretrial affidavit?
She did not.
In fact, when you filed the pretrial affidavit, did Becky ask you, did you put in there that she still wanted that to be returned to her?
She did, and if it would not be returned, she was seeking the fair market value of it, which I believe was close to $800.
You said that there was also disagreements about finances. Was that something that Becky looked into herself as well?
Yes, she looked into it in great detail. She went back a number of years. The final figure that I came up with approached $481,000, and what she was going to put out to the court as discrepancies on money that her husband had either taken or things that he had understated, and she felt that she should be entitled to.
Objection, Your Honor, to what?
That will be sustained as to what she felt.
When you put the pretrial affidavit together, did you put in specific numbers about what you were seeking as far as additional assets that the defendant disagreed with?
Yes.
And did that total almost $500,000?
I believe it was.
Objection, Your Honor, what's the foundation? I don't know that the people, can we approach?
You may.
Your Honor, she's doing it again. Your Honor, we talked about this in the prelim, and now they're doing it again. Okay, and we get siren in the right ear. Even though it's noise, I'm glad to have some noise in the right ear. She's like, calm down, kids, calm down. I'm in charge. You said this. And she's like, yes, man. You're like, okay. Don't go back and forth with this constantly. We have a court to move forward. You hear me? Do I have to separate you two? Because I can do it. I'll do it. Make you sit in the back of the courtroom. She's like, I won't do it. It's like, oh, okay, we're fine. I have no idea what they're talking about. It's a show. It's a show, and it serves her purpose. It shows frustration with the witness.
The objection is overruled. You may proceed.
Thank you. Do you need me to restate my question?
I think that you were asking me how much money was involved, and I believe it was $481,000 in discrepancies, and she was, her pretrial affidavit, she was seeking that half of that be awarded to her in some fashion.
In that pretrial affidavit, did you also lay out what Ms. Bliednick was proposing as far as parenting time?
Yes.
What was her proposal for how much each, both her and the defendant, should get the children?
50-50.
So they would each get the children half the time?
Correct.
Split custody.
In December 28, 2022, did the defendant's attorney on his behalf file a pretrial affidavit as well?
Yes.
In that pretrial affidavit, what was the proposal for how much parenting time that the defendant thought he should get?
I believe he was at 60-40 is what his proposal was.
And in the child support and maintenance calculations that Becky put together for her pretrial affidavit, the child support was $462, is that right?
That's correct.
And the maintenance was $1,346.
That's correct.
Did, as divorces go, often attorneys exchange letters with proposals as well, is that right?
That's correct.
Mr. Timberwolke, I'm handing you what's been marked as People's Exhibit 73.
Ashley, I'm just glad you're here
Tell us
now.
what that is.
This is a letter I received from Tim Bliefnick's attorney, Ms. Casey Schnock, that was a proposal to settle the case.
Your Honor, I'd ask that People's Exhibit 73 be admitted and published, please.
Any objection, Ms. Schnock?
No.
It will be admitted and you may publish it.
I haven't done a lot of merchandise. If there's an item of merchandise you'd like me to do, let me know. I'm not big on merchandise, but if there's something that you guys would, a lot of you would agree on, then I think that is good. That I'd be happy to try to get something for you. Michelle, we've had a couple spicy moments on here. Obviously, we're bringing in divorce court proceedings into a criminal trial. So yeah, it's getting a little in depth in areas we didn't think we'd get into. A little spicy. We've had to edit out some pictures just because I don't think they were relevant. We don't need to show what they showed, but. We're getting the gist of it.
Okay. That's why you have it, right there.
The monitor was not turned on. Looking for the remote. Can you do a cash baby doll? I like this idea. Carrie Brooke, I like that one.
Mr. Timberwolke, this is the letter, as you said, it's dated January 3rd, 2023, correct?
That's correct.
There are a number of
Can't read it.
things that are in this letter, but I want to specifically talk about the first bullet point that's in the letter on the first page to the far, the left as we're looking at it.
I have it here. I can see it here. Just.
Mr. Timberwolke, I'm talking about this right here at the top. And that, Mr. Bliefnick's attorney says that parenting time would be allocated on a 60-40 basis. So 5 overnights in a 14-day period for Becky and 9 overnights for himself. And it goes on to talk about how that would work. Now, up until that time, they've been exercising 50-50, correct?
That's correct.
So the entire time the divorce had been pending since It was 50-50, and then he wants to go to 60-40, where he gets the children more.
That's correct.
And as you said, Becky's proposal in December in her pretrial affidavit was 50-50.
Corey, that's a good one.
He then also talks about how on the top of page, of the second page as it's scanned in here, the second bullet right here, that if your client, Becky, has a psychiatric evaluation and any recommended treatment, he may be willing to consider a 50-50 split if there are no more, quote, incidents of abuse. Is that right?
That was his proposal, yes.
He also, in the letter, says that he will not have to pay any child support. Is that right?
That was his request, yes.
And finally, with regards to maintenance, he says that her client will pay $750 per month. Is that right?
That is his request, yes.
And I'm sorry, I forgot one other thing. He also says here in the bottom middle part, that her client, the defendant, would receive the marital residence and Becky would have 60 days to get out and find suitable housing.
True.
And this is when they say the marital residence, they're referring to the residence at 2528 Kentucky Road, where Becky had been living with her children since the divorce began, actually before the divorce began. Is that right?
That is correct.
There also in the letter, on the third part here, this top bullet, says that client's father, Ray Bliefnick, would be allowed to have unsupervised visits with the children. Now, earlier you told us how that was one of the things that was contested. What was Becky's position about the defendant's father having any unsupervised contact with the children?
That was non-negotiable with her. She was ready to put on evidence, 5 witnesses that would support the position that Ray Bliefnick should not be around the children unless supervised.
Was this something that she was ever going to agree to?
She would have fought that all the way through the trial court and above.
When you received this letter from the defendant's attorney, did you share it with her as her client, with Becky Bliefnick?
I did.
What was her response?
Objection.
Objection is hearsay?
Yes.
Okay, and that's not one of the ones that we discussed. The response will be sustained. You may rephrase your question, however, Ms. Keck.
Did you speak with Ms. Bliefnick about the letter?
I did.
After you spoke with her, what did you do?
I contacted Ms. Schnock verbally and told her the answer was no.
Thank you. After you told the defendant's attorney that the answer was no to her proposal, was this case ready for trial?
I believe it was, yes. I was fully prepared.
Now, fair to say, the divorces often get set for trial a couple of different times and then get continued, right?
It happens, yes.
But you get to a point where pre-trial affidavits are filed, you're subpoenaing witnesses, and you're ready to go.
True.
On February 15th, 2023, was there an order entered in the divorce case?
I believe there was.
And did that set the case for trial?
Yes. That was the order setting it for trial, 5 days, a day, and then a full day, and then half days due to the judge that was assigned to the case had a difficult schedule and her other obligations, so we did it in half days mostly.
And Mr. Tremolke, I'm going to show you that divorce order from February 15th, 2023, which is part of People's Exhibit 72. And this was the order that we're discussing that was entered on February 15th, 2023, correct?
Yes.
And that order specifically set the first day of trial on March 2nd, 2023 at 1:00 p.m.
Correct.
It also noted in that order that all issues would be decided during those 5 days.
Correct.
And that bottom part says that respondent will not be expected to present evidence any time before March 3rd, 2023. Is that because you had witnesses that needed to testify?
Yes, some of those witnesses were away. They did not live in Quincy, so it was a matter that the court accommodated by giving us a start time with our witnesses.
Did you in fact have multiple witnesses subpoenaed after this order was entered that were going to testify March 3rd of 2023?
Yes, I had 5 witnesses.
Did you also expect that during this divorce proceeding that Becky Bliefnick would testify?
Absolutely.
And specifically, did you expect her to testify about finances?
Yes.
Did she ever get to do that?
No.
Did you expect her to testify about the defendant's father?
Yes.
Did she ever get to do that?
No.
Did you expect her to testify about parenting time and how much time she would get to spend with her 3 boys?
Yes.
Did she ever get to do that?
No.
Did you expect her to testify about maintenance?
Yes.
Did she ever get to do that?
No.
After this order was entered, was there a additional GAO report that was entered?
Yes.
And did that report recommend that there be continued 50-50 parenting time?
Correct.
When you receive things like a GAO report, do you then send that on to your client?
Yes.
And is that what attorneys do? They send GAO reports and other things like that on to their clients immediately?
Sure, yes.
Mr. Termolke, did you, at the request of our office, put together with a 60-40 split based on what the defendant had proposed, what the calculations would be for child support payments?
I did.
Show you what's been marked as People's Exhibit 74.
Before you start, Ms. Keck, the exhibit, the schedule order that you showed, the court is labeling that as 72C so that we can make record and identify to that, and then you may proceed.
Thank you. Your Honor, Mr. Termolke, could you please tell us what People's Exhibit 74 is?
You asked me to calculate if Mr. Bliefnick would receive 60% of the parenting time and Becky would receive 40%. The child support guidelines in the law in Illinois, that's one of the 5 factors that go into how you calculate support. So that would have required no...
And so that's what People's Exhibit 74 is?
Yes.
Your Honor, I ask that Exhibit 74 be admitted and published, please.
Any objection, Ms. Schnock?
No, Your Honor.
It will be admitted and you may publish it.
So, Mr. Termolke, this is as you said, there's a formula that's used by the state of Illinois, correct?
That's correct.
And this is a form that puts that formula basically together. Fair to say?
Yes.
Now, this form, obviously, the courts can deviate from this.
True.
So they could go up or down based on what they think is going on in the case, or the individual case, right?
Yes. Child support and maintenance are in the sound discretion of the court.
But if there is no deviation, this is what would be ordered.
Correct.
And in this
Objection, Your Honor. I don't know that we could, that's a fair conclusion based upon the evidence. I mean...
That will be overruled. People are allowed to present that evidence, and it goes to motive as well as the reasons that the court allows the hearsay statements. So you may proceed.
Thank you, Your Honor. And so we see down here, this is if It says percent of overnights. If Becky gets 40% of the overnights and Tim gets 60%, that's what this is based on.
Correct.
And under those guidelines, there is, the defendant's not ordered to pay any child support.
Correct.
And maintenance is $1,379.42.
That's correct.
In determining whether or not to order maintenance, one of the things that the court may consider is the disparity in income, correct?
Correct.
They also may consider in determining whether to order maintenance if financial assets are being hidden.
Yes.
At the time that Becky was killed on February 23rd, 2023, had you received any information from the defendant's attorney that the defendant had given up that CZ-75?
No.
Had you received any information from Becky that she had gotten that gun back from the defendant?
Never.
No other questions, Your Honor. Thank you.
Ms. Schnock, before you start, Mr. Timberwolke, I'm going to ask you to explain a few things.
This judge just interjects himself.
We use terms as attorneys that lay people may not be familiar with. So first of all, we made reference to a GAL report. The GAL stands for guardian ad litem, is that correct?
That's correct, Your Honor.
And in this case, there was a guardian ad litem that was used, is that correct?
Yes.
What is the purpose of a guardian ad litem?
A guardian ad litem doesn't represent either parent. The guardian ad litem represents the children. The ultimate goal is for him to make a recommendation, in this case it was a he, to make a recommendation to the court as to what's in the best interest of the children. That would include parental decision-making and parenting time.
And Mr. Timberwolke, that guardian ad litem, at least in this case, is appointed by the court, is that right?
That's correct.
And is that an unusual procedure?
It is not unusual. In contested matters, it's often done, that procedure is done, and it benefits and assists the court in making its final decision.
Okay. Thank you, Mr. Timberwolke. Ms. Schnock, you may proceed.
Thank you. Mr. Timberwolke, am I correct that you would have gotten involved in this divorce sometime around November of 2021?
You are correct.
Okay. And during your involvement in this case, there was extensive discovery that was exchanged, correct?
Correct.
And along those lines of discovery, disclosures would have been witnesses that would testify at trial, correct?
Correct.
And the witnesses that testify in any divorce trial are required to be disclosed if they are requested in discovery, correct?
That's correct.
And in this matter, that request was made of you and Becky to disclose all witnesses, correct?
That's correct.
And that was done, correct?
Yes.
And so it was no surprise that these people were going to be testifying in the divorce matter.
Objections. Cause for speculation.
In this case, that'll be overruled. You may answer, Mr. Timberwolke.
It should have been no surprise, right?
Okay. Everybody knew it was coming.
Hopefully, yes.
Okay. Also, during the course of your representation of Ms. Bliefnick, you never personally filed for an order of protection naming Tim as the respondent, correct?
That's correct.
And even though there was that scheduling order entered with the court setting this matter for March, that was not the first setting of the final divorce, correct? It had been set for final hearing at least twice prior to that. Is that fair?
I would have to review the docket on that. I'm not 100% sure.
Your Honor, I would request that Mr. Timberwolke be allowed to review the docketing statement.
If you reviewed the docking statement, would that refresh your memory, Mr. Timberwolke?
It could, yes, Your Honor.
Let's see if he has to stand up and peer over the wall. He gets the paper. French fry, have fun over there. Tell everybody hi. Tell Brandy I'm 8 people away from 22,000. Hope you guys have a great stream over there. She's awesome. The sound is bad, but it's so much better than it was this morning. I can live with this. I mean, it sounds like we're next to a roaring river or maybe a gentle beach with crashing waves, but other than that, it's good. Honestly, I think if we want to hit the 22,000 during this live stream, the best way to do it is to click the like button. That impacts how people see the stream on YouTube and the algorithm, and it brings people in. But thank you. Obviously, if you don't like the video, don't click the like button. Just click the dislike button twice, and we'll be good. Review every page of this. This is his chance, really. I mean, he's going to take his time to get all the information in. Good. If I had 8 more friends, we'd be at 22K. Thank you, Daisy. Appreciate it. What's happening? The witness has been, as asked, was basically said, if I could see the docket and it could refresh my memory, I'd be able to answer your question. And so the judge verified that, and now he's given him the list of all the happenings in the divorce proceedings.
Mr. Timberwolke, to save time, I have pulled up the document, the docketing statement in the minutes. It looks like there's an order entered 11/17/22, setting it for hearing, and 9/30/22.
Yes, Judge, I just saw the 9/30/22, so in answer to her question, I believe that it was scheduled for hearing. The first order setting it for hearing was on 9/30, and it was scheduled for December 29th.
Thank you, Mr. Timberwolke. Ms. Keck was asking you about pretrial memorandums. And in her questioning regarding pretrial memorandums, she referred to them and you agreed that they're essentially a proposal to the court, correct?
Correct.
It is a litigant's position on what they believe the assets are, what they are worth, and what they think they should be done with them, correct?
Correct.
Within the bounds of the law.
Correct.
Okay. And if you don't ask for something in a pretrial memorandum, it's hard to ask for it at the final hearing, correct?
True.
Okay. And so when you file these pretrial memorandums, you want to make sure that they are as accurate as possible, correct?
Hopefully, yes.
Yes, okay. And as part of Becky's pretrial memorandum, you ran child support and maintenance calculations in preparation for the hearing, correct?
Yes.
Okay. And the child support and maintenance calculations in divorce courts in Adams County, we rely upon financial affidavits, correct?
True, in part. There's other things.
There's other things that go into it, but the financial affidavits lay out the parties' prospective income, expenses, certain deductions and the like, correct?
Correct.
Okay, and as divorce attorneys, we don't have to agree with somebody's financial affidavit, correct?
That's why I answered the other question. You don't always rely on that because the financial affidavit gives a figure by a party to it, but the best thing would be, for example, a check stub.
Sure, absolutely,
right.
Absolutely. And in calculating maintenance and child support, did you use a computer program that's commonly used in divorce court to generate child support and maintenance calculations within the Illinois statutory guidelines?
I did.
And did you prepare that on or about December 15th, 2022?
It would have been part of the pretrial, yes.
Okay, Your Honor, may I approach?
You may.
Okay. And I'm not offering this as an exhibit, Mr. Crystal, simply to refresh your recollection. With this
Objection.
That's serious.
We still have to mark it.
Judge, she said she's offering it to refresh his recollection. He's never said he needs to have his recollection.
That will be, first of all, if you'll mark it, and then that will be sustained.
Do you recall what you would have included in Becky's income in preparation for trial?
I would have used the information that I had for her as a nurse.
Okay.
And I would have used the most current information I had because she had returned, I believe, to Blessing Hospital by that time.
Okay. Now I'm handing you what is marked as Defendant's Exhibit 2. And are these the calculations that you provided in part of your pretrial memorandum?
That's Exhibit Q, I remember.
Okay, and as part of the maintenance calculations, what is the maintenance, and to be fair, that was going to be your request, Becky's request of the divorce court at the final hearing, correct?
Correct. This would be based on 50-50, and this is what she believed to be the correct maintenance and child support based on their incomes.
Okay, so that was her best case scenario as far as child support and maintenance calculations were as far as your request was concerned.
Objection. That's not what he testified to.
That will be overruled. This is cross-examination.
You can answer, Mr. Timothy. Let me rephrase that question.
Yeah.
You wouldn't ask for something on behalf of a client if it wasn't in their best interest.
That's correct.
Okay, and as part of the calculations that you provided to the divorce court, the maintenance amount was $1,346, correct?
True.
And that was what you prepared in December of 2022 in preparation for trial in March, I think, correct?
Correct.
And then Ms. Keck subsequently asked you to provide calculations based upon a 60-40 split, correct?
That's correct.
And that was what was identified as, I think, People's Exhibit 72C, is that correct? 74.
That's correct.
Okay, so 74 was prepared for preparation for this trial, correct? It was not prepared for the divorce trial, okay? And the calculations for maintenance in People's Exhibit 74 is the same amount that is in Defendant's Exhibit 2, correct? 1,300, and almost identical.
The maintenance was correct, but the child support was different.
Correct, and so what is the maintenance amount on that figure that you have in front of you?
$1,346.
Okay, so the document that you prepared for trial was a maintenance amount of $1,346, correct?
True.
And you would agree that $1,346 is less than $2,100, correct?
Correct.
Okay, and 1,346 is still less than 1,379, correct?
So he lowered what she was getting?
Okay. And these numbers are assuming that a court, or that you accept the gross income of both parties is true.
That's correct.
Okay. And in People's Exhibit 74 that was presented to the court, that does not include the amount of maintenance that she was receiving from Mr. Bliefnick, correct?
You mean the existing order while the case was going on?
I'm talking about Exhibit 74 that was prepared in preparation of today's trial, and if the people want to hand that up or... And so People's Exhibit 74 does not include any amount of maintenance that she was receiving from Tim, correct?
You mean going into the trial?
I'm talking about what that document has right there in front of you. That includes her base income, correct?
Yes. Yeah, you mean her base income of $5,452 a month as a nurse?
Yes. And that's what she was claiming her base income was, correct?
True.
Okay, and that document that you have in front of you does not include the maintenance that she was receiving from Tim under the temporary order.
No, this would be the projected. The temporary order was different.
No, I understand that, but the line items on Exhibit 74 do not account for any maintenance being paid. Her income does not include the maintenance that she was receiving.
Correct.
Okay, thank
Right,
you. Thank
right.
you. I can take that back. And so if that calculation had included the maintenance, then that could affect the calculations as well.
I've never included the maintenance as part of the income. The party's income from their employment in this case, for both of them, would be used to determine maintenance. You wouldn't also add on the maintenance.
Correct.
That's how you arrive at the maintenance.
But you would agree that's not included in that form?
I would agree it's not included in the form, right.
And in this matter, there was a dispute as to what Becky's income was, correct?
At one point, there was a major dispute, but by the time we went to trial, she had now returned to Blessing, and her income had stabilized, because there was a period of time where she left and went to Kirksville, and she was a contract worker, which means she made a lot more money, and she was getting expenses for living expenses while she lived there and stayed there overnights while she worked.
Okay. And also in the preparation of your pretrial memorandum, you did not include any cash that Ted Johnson or anybody else for that matter was holding for her, did you?
I did not.
Okay. Did you even know about $13,000 in cash being held on her behalf by somebody else?
I did not.
During your representation of Becky, did you ever file any petitions to show cause with respect to non-payment of maintenance?
No, there was something earlier, but I was not in the case at that time.
Okay. And you did not address any maintenance or child support arrearages in your pretrial memorandum, correct?
No.
Okay. As far as divorce procedure is concerned, it's not uncommon to try to settle cases before trial, correct?
It's not uncommon, that's correct.
Okay. And sometimes efforts work and sometimes they don't. Is that fair?
True.
Okay. And in reference to the settlement proposal that Tim sent, he was not unwilling to pay maintenance, correct?
Objection.
What's the objection?
Speculation.
It says it right.
Rephrase the question.
It says it
please,
right
Ms. Dodd.
there. She's
In
trying to
the
say.
letter that Tim sent to Becky, he offered to pay maintenance monthly, correct?
He did.
And he offered to pay that for a period equal to 1/2 of the duration of the marriage, correct?
He did.
Okay. And the marriage was approximately 11.2 years, a little over 11 years.
He arrived at 70 months. I believe that's the way he did it.
Okay. And he was also, he was willing to continue doing that, and he was also willing to continue to pay for things like St. Peter's tuition, correct?
Yeah, but he was willing to pay maintenance, but he only wanted to pay $750.
Sure, and that could have been something, the divorce court could have accepted your number, sure, she could have accepted anybody's figures or could have done anything different that she wanted. As you said, that's in the purview of the court, correct?
That's true. The court would make the final decision.
And as part of this letter, it was requested that proof be provided that a gun safe was purchased by Becky, correct?
Yes.
Okay. And you stated with Ms. Keck, the only thing that you did after you received this is just say, no, we don't have a deal, correct?
That's correct.
And so there was no proof sent that there was a gun safe purchased by Becky. At least you did not do that. Is that fair?
No, it was a simple no. It was rejected due to the many terms and proposals he was making.
Okay. And as far as the guardian ad litem report that you referred to, the recommendation was part of the second supplemental report of Mr. Zimmerman, correct?
The 50/50?
Yes.
Yes.
And that was made by Mr. Zimmerman on February 20th, 2023, correct?
Correct.
Okay. And he made several observations of the parties and their issues as part of that report, correct?
Yes.
And the biggest issue at that point was their ability or inability to communicate effectively, correct?
Yes, he showed concerns for that issue.
No other questions, Judge?
Jimmy, it's hard to tell, but this is a murder trial. It happened to be a murder trial that came about shortly after the divorce trial began.
After Becky Bliefnick was killed, how much maintenance was the defendant going to have to pay?
Objection.
That will be overruled.
0.
No questions, Your Honor.
Boom.
You may step
Objection.
down.
Thank you, Your Honor.
Put your hand up.
Sure.
That was awesome.
Mr. Jones or Ms. Keck?
People would call Rick Zimmerman to the stand.
Ladies and gentlemen, while we're waiting for Mr. Zimmerman, you are free to stand up and stretch.
Here
if
comes
you
the
wish
noise.
to.
Barn doors have been opened. A stampede is ensuing.
You don't have to, just stretching. Yeah. And honestly, I need more of this than I do. Not yet. I have them right here, though. Why?
Stretching, Mr. Zimmerman. That's fine.
He walks into the courtroom. He's like, "What is going on? Why are people running laps around the jury box?"
Please be seated. If you'll step to the front of the courtroom, raise your right hand and be sworn.
You do solemnly swear that the testimony may give in the cause and opinion before this court should be the truth, the whole truth, and nothing but the truth, and help you God?
I do. Come around here. Have a seat in the chair, scoot up to the table to where you're comfortable, and then bend the microphone so it's in front of you, and please speak towards the microphone.
I don't know if
And
I've
Mr.
ever
Jones,
seen
you may
a
inquire.
shorter
Can you tell
haircut.
your name, please?
Rick Zimmerman?
What do you do for a living?
I'm an attorney
Where do you work at, Mr. Zimmerman?
in Mount Sterling, Illinois.
What kind of law do you practice? What's your focus?
General practice, primarily criminal defense and family law.
Anything that comes to the door.
Is there a particular role that you sometimes fulfill at the request of a court?
Yes.
And what's that role called?
I serve as what's called a guardian ad litem.
Sometimes we'll hear that called the GAL, is that right?
Yes.
Guardian ad litem is how attorneys get paid $250 an hour. That's one stuff.
Well, the rate varies, yes. But
Can you tell me what a guardian ad litem is?
simply, the role of a guardian ad litem is to represent the best interests of the children involved in the case, whether it be a divorce, a family, or other type of case.
So if there's a divorce or some type of family case, the court will appoint an attorney who's not representing the mother, not representing the father, not representing the husband, not representing the wife, but who's there to represent the children that are
Are
in
there other people they're not
The best interest
representing,
of the
like
children, yes.
neighbors?
the best interest of the children.
Yes.
How
Take the
long
bottom
have
end
you
off
done
this.
that?
As far as doing guardian ad litem work, I think 2, maybe 3 years.
And I know we've covered this, but you're appointed by the court, you're not hired by the parties. Is that also correct?
That's correct.
So you're not there to make a decision that favors one side or the other. You're there to look for the best interest of the children.
Yes.
How do you do that as a guardian ad litem? How do you decide what you're going to tell the court and the parties that, in your opinion, is in the best interest of the children?
I'll conduct an investigation. During that investigation, I'll talk to both parents. I'll talk to the children. I'll talk to third parties if there are third parties who have information that's relevant, and often I'll review documents submitted by the parties as well.
In reviewing those documents, are those documents, does that include sometimes text messages from the Our Family Wizard app?
Yes, sometimes.
What is the Our Family Wizard app?
It's primarily a communication tool and used in divorced families or separated families.
I forgot.
It allows the parties to communicate, and those communications to be monitored, and prevents either party from tampering with the communications.
Is it an app on your phone?
It can be, yes.
And is it a messaging app? So if you're going to, let's say, for example, a husband and a wife are ordered in the process of divorce to use the Our Family Wizard app. If they're going to message each other, they are ordered to type
Songs in my head
messages
now.
into
That
the
quick.
Our Family Wizard app. Is that right?
Yes.
And then the app will send the message to the other party?
Yes.
The application records that message?
Yes.
It sends it to the other party. If the other party chooses to respond, they're required to respond through that application as well.
Yes.
And you did tell us this, but that app records those conversations, stores those conversations so that they can be reviewed at a later time.
Yes.
Are you one of the people that can review those messages?
I have in the past, yes.
In this case in particular, were you appointed to be the GAL for the 3 Bliefnick children, Grayson, Arlen, and Pete?
I was.
When were you appointed to do that, if you recall?
I believe it was in 2021, sometime in the summer, I'm wanting to say.
When you are the guardian ad litem, you said you performed an investigation, is that right?
Yes.
Did you do an investigation in this case?
I did.
You told us in general you'll talk to both the mother and father. Did you do that in this case?
I did.
You told us that in general you would talk to the children. Did you talk to the 3 children in this case?
Yes.
Specifically with regard to the defendant and Rebecca, his wife, I guess I should ask you this. Do you see the person in court that you spoke with that you know as Tim Bliefnick?
Yes.
Can you point him out, Mr. Rogan?
He's sitting at the end of the council table, wearing a sweatshirt.
We'd ask that the record reflect he's identified as the defendant.
The record will reflect that the witness has identified the defendant.
You spoke with the defendant in your investigation?
Yes.
When you speak with these parties, what kinds of questions are you asking them? What are you talking to them about?
Typically, I'm asking them about their background, the history of the relationship between the parents, the typical relationship they have with their children, any incidents that may have occurred that reflect what has led to the breakdown of the relationship, and what they would like to see happen as a result of the court case.
And when you say what they would like to see happen as a result of the court case, are you talking about parenting time, custody split, things like that?
That's correct.
Did you speak with the defendant about those issues, parenting time, custody split?
Yeah, I have.
And when you spoke with the defendant, what was his position?
His request was always that he have majority parenting time.
At that point, when you were the guardian ad litem, were you aware of what the current, I'll use split, or the current divide was?
I was. It changed at several points during the course of the divorce, but I was made aware of it, yes.
And at that point, what was the custody division?
The most recent was it was 50-50, or equal division.
Did you also speak with Becky Bliefnick about the custody division?
I did.
And what's her position that it should be 50-50?
Yes.
Did she also share with you a concern that she had, not about the custody split, but about who could be around the children?
She did.
And what was the nature of that concern?
She was concerned about Mr. Bliefnick's father being around the boys.
Did she want the 3 boys to be around the defendant's father?
Not in an unsupervised capacity.
Did you review the text messages on the Our Family Wizard app between the defendant and Ms. Bliefnick?
I did not review the entirety of their text messages. What I did was just kind of took a random selection to get an idea of the communication between the parties.
And you also spoke with Mr. Bliefnick, the defendant, and Rebecca Bliefnick?
Yes.
What was your sense of the divorce, how the divorce was going based on the review of the text messages and the conversations that you had?
It was a very contentious divorce. It was hard for the parties to find any kind of agreement, it seemed like.
And I want to be fair, was there animosity on both sides? When I say that, was there animosity from Rebecca towards the defendant, and was there animosity from the defendant towards Rebecca?
Absolutely, both ways.
It went both ways?
Yes.
In reviewing the messages, were there, I won't say inappropriate, but were there messages that dealt with that animosity that you reviewed from both sides?
Yes, it was clear they were arguing in the messages.
In the course of the investigation, did you speak with me about those conversations? The animosity?
Did I speak with you regarding it?
In preparation for trial?
Oh, yes.
And talking about that, did you tell us that they were basically fighting about everything?
Yes.
Fair to say?
Yes.
They would make mountains out of not just molehills, but hills?
Yes.
I also want to be fair in reviewing the messages that you reviewed.
We might see if they try to bring it in.
Or see any acts of domestic battery?
No.
Thank you. That's all the questions I have.
I think this is our last witness for the day. We might have one more.
Thank you. Mr. Zimmerman, as part of your involvement in this case, you filed a second supplement to report a guardian ad litem, correct?
That's correct.
And you filed that on or about February 20th of 2023, correct?
Yes.
And would you have met with both Tim and Becky prior to preparing this report?
Yes.
Okay, do you remember when you last met with Tim?
Off the top of my head, I don't. I do have my notes if I need to refer to those.
If that would refresh your recollection, I would ask that you be allowed to do so.
We have no objection.
All right, you may do so.
The note I had from my last meeting with Mr. Bliefnick was on February 17th of 2023.
And how long did that meeting last?
I don't know off the top of my head. I don't believe it was a very long meeting.
Okay, and when was your last meeting with Ms. Bliefnick?
It would have been on February 16th of 2023.
All right, and did either of those meetings involve the kids?
I don't believe so, but I did meet with the children for the last time also on the 16th, but I think they came in, I seem to recall Ms. Bliefnick may have came in and then come back with the children later.
Okay, that's fair. And this was the final report that you filed prior to the scheduled hearing date in March, correct?
Yes.
And before you filed this, it had been quite some time since the report had been made to the court, correct?
That's correct.
And so the court was requesting an update on things had been going since the last report was filed. Is that fair?
Yes.
And the current parenting, were you made aware of the current parenting time schedule that they were operating under at that time?
Yes.
And was that schedule agreed upon by Tim and Becky?
Yes.
And that was that Tim had the kids on Mondays and Tuesdays, Becky had them on Wednesday, Thursday, and they were alternating who had the weekend, correct?
Yes.
And both of the parties reported to you that they were able to come to that agreement without court involvement, correct?
Yes.
And so for two people that were making mountains out of anthills, they were able to come to an agreement on a schedule without the need of their attorneys or a judge. judge, at least at this point, correct?
That's correct.
Okay, and as divorce attorneys, that is something that you like to see when you have two people that are making mountains out of anthills come together and agree on something without the need of two attorneys, a guardian ad litem, and a judge.
Absolutely.
Okay, and you mentioned at the back end of your report that neither party seemed inclined to want to continue to agree to that schedule.
That's correct.
Were they both wanting to make changes to that?
Mr. Bliefnick expressed that he did not like the schedule. Ms. Bliefnick was not happy with it, but seemed more willing to go along with it.
So neither one of them liked it, but they agreed to it nonetheless?
That's correct.
And was that in large part because it was working for the boys?
I believe so.
And when you get a parenting time schedule together, you're more, as a guardian ad litem, more concerned about how it works for the kids as opposed to how convenient it is for mom or dad. Is that fair?
Absolutely.
Okay. As part of your report that you made on February 20th, you made the observation that the biggest issue at that time was the parties' inability to communicate effectively to one another. Is that fair?
Yes.
And there were certain accusations made on both sides regarding communication, correct?
That's correct.
As far as those allegations are concerned, were they fairly innocuous?
Yes, I mean, the parties were not communicating well, but I mean, it wasn't violent or anything like that.
Sure. And after you met with both Tim and Becky on these last respective occasions, you had no red flags going off in your mind that things were going poorly. Is that fair?
Yes.
Okay. And there was nothing in your mind that the children were unsafe with either parent, correct?
No.
There were no safety issues with respect to the kids, correct?
Not that I was aware of.
And there was nothing in your report that alluded to any red flags with respect to domestic violence, correct?
Correct.
And as part of your report, you also recommended joint decision-making, correct?
Yes.
And a joint decision-making scenario is when you expect mom and dad to come together to make decisions for kids, such as where, what sports team they're going to play for, what daycare they're going to go to, what doctor they're going to go to, correct?
Yes.
And joint decision-making tends to require some amount of cooperation on the part of both parents, correct?
Yes.
And despite the fact that earlier in the divorce they were making mountains out of anthills, you still believe that they could come together to make decisions for the best interest of the kids, correct?
Yes.
And that's what you hope for, correct?
Yes.
Now we have molehills, anthills.
Your Honor, may I approach?
We have all the hills.
Mr. Zimmerman, I'm handing out what is marked as Defendant's Exhibit 3. Is that your second supplemental report?
Yes.
And is that your signature on the back page?
Yes.
Your Honor, I would ask that Defendant's Exhibit 3 be admitted.
Any objection?
It's part of 72, so it doesn't need to be because it's already part of.
I would just add, I guess it could be a joint exhibit.
That's fine, I don't have a problem.
Okay.
What the court's going to do, because that is part of Exhibit 72, which has been admitted, then I'm going to have you change the markings on that, and we will call it 72D.
Peoples.
That's fine.
Okay.
So that it can be found and made a record of, and it can be considered part of a joint exhibit.
Your Honor, may I approach?
You may.
There's the correct exhibit, Robert. That was.
All right, I have no objection to that being offered and introduced, Your Honor.
Okay. And then Ms. Keck? Mr.
I'm done.
Jones?
Mr. Zimmerman, I want to talk about that last conversation you had with Tim Bliednick on February 17, 2023. And in regards to the current parenting plan, was the defendant wanted more than 50-50, is that right?
Yes,
So he was not happy with the 50-50 split.
that's correct.
The victim, Rebecca Bliefnick, didn't like the 50-50 split, but was willing to go along with it.
Reluctantly so, yes.
After Rebecca Bliefnick was found murdered, did she have any parental rights at that point?
I would assume no.
That's all the questions I have.
Ms. Stock, want another shot?
Nothing.
All right, you may step down.
Thank you, Your Honor.
Okay, this is going to conclude this this segment. We have not taken a lunch. You guys reminded me. You should have said, "Hey, I'm starving. RA, please let me leave. Let me make a sandwich. Let me get some pickles. Let me call an Uber Eats or something." But they're going to approach really quickly. They're going to take lunch. We have one more video that's dropped. I think I want to save it for tomorrow. Is that all right? It's that way we're going to be just like a day behind, because if we watch this video and they take another 2 days to drop another video, then we have nothing and a gap in the middle. And it's hard to have a gap, pick up another trial, and then come back and pick up where we were before. Everybody who's here is already subscribed. Honestly, I think everybody here is a subscriber. We are at 21,995.
Okay, ladies and gentlemen of the jury,
Test 1, 2.
we have issue as far as other witnesses go. We are going to break for lunch now. We've got some work to do before we have that next witness. So you are free to go to lunch. You are to return back to the jury room by 10 till 1, because we will plan on starting right at 1 o'clock again. So you are free to go for lunch.
All right.
Muddy River News. Our home, our news.
Yeah. Thank you for that, Muddy River. We're done with that video. We're done. Can we do tomorrow? We're free. Yeah, five more people. And honestly, it's not the people that are here that have not subscribed. I think everybody here subscribes. In the YouTube world, it is extremely rare to see the subscription rate as high as this channel has, compared to the viewers that view it. Generally, the number of subscribers to watchers, the percentage is usually around 30 some odd percent. We're like high 80s. So it's you guys that are here, you guys have subscribed, and a lot of you watch on multiple devices. So you might subscribe on your phone and then watch on your TV, but the TV, you're not able to like or subscribe or even technically log in. It just depends on how the TV works or how you've got it set up. So that can explain some of that. So I don't think you guys are the problem. We might need to bring some other people in here to get to the 22,000. Tomorrow works for you guys. Does that work? We've listened to such bad audio today that we've missed a little bit. We have tomorrow's video that we have so far. It's the only one that's dropped for yesterday's events. Let's see. Let me look at this. We have. Okay, hang on. We just watched the 24th in the morning, so we have the afternoon. That was the morning one. So we have the afternoon from yesterday to watch. We haven't seen anything drop for today yet, so that makes sense. We've got an hour and 41 minutes of video that we're going to watch tomorrow morning. There's some other things we can also cover and talk about in the world of true crime, that in cases that we followed together. The Murdaugh issue. Alex Murdaugh was just charged with a bunch of federal crimes. He got served with paperwork basically saying, hey, jailer, just know you have to deliver him to the courthouse because we have United States versus Murdaugh that's going to be going on. And just FYI, that's coming up. So that's something fun to listen to as well. I did try to make a spicy maple bourbon pickle shirt, and I don't know how I can get it. I posted the link in chat, and I don't know if you guys like that link. It's sort of like a big jar of pickles that says politics, not pickles on it. It doesn't say spicy maple bourbon. It's just politics, not pickles. I've got it in a couple different designs. Let me know if you want something smaller or just text without imagery or anything. I know a guy who can help me design it. I'm not the graphic artist that he is. Let's see. Sounds like the judge is on slow mode. He is a deliberate speaker. Cover Addict has better brand loyalty than Apple. I do. How about that? You guys are amazing. We are special, I tell you. Yeah, you've said it all along, Rudy. I believe you. Wait, I can sub on my phone? Skyfire, I'm just saying that it's easier to sub on a computer or a phone than on a television a lot of times. Because the login process to YouTube on television usually has to be done using a remote, and a lot of people don't log in on their TV or know that they can. So should be 4 more. My one just subscribed. Let's see. I think I subscribed to your one's channel as well. It's 2 more. We're at 21,998. We need 2 more subscriptions, then we'd be at 22,000. That's really close. Plot twist: there's only 50 of us here, and we're watching on multiple devices. Lost soul, thank you. That would explain the quiet chat today. It has been sort of quiet. When YouTube bans me for using ad block, I'll only be able to watch from that point on. Hopefully they don't ban you. Jim Bob, I try to turn off as many ads as I possibly can. I specifically do not tell it to put ads in the middle of the video. I don't think it's fair for somebody who's watching court and has been, supporting, watching, viewing for so long, dedicating time to my channel, to suddenly interrupt the court session with an ad that either they have to wait a certain number of seconds to skip, or they don't get to skip at all, and then it just comes back and they've missed whatever it was. So I don't allow that on YouTube. I try to block everything I can, because I would hate having an ad pop up in the middle of that as well. Let's see, spicy pickles rule. And you're going to enjoy the rest of the day. You know what's going to happen? We've got to work on the Airbnb. We have we've put in most of the wiring. It's ready to sort of be installed. But I drilled the hole for the dryer vent to go out through the wall and through the siding and everything. Did that just the other day, and now I have to go through with that expanding foam and fill in the little cracks around any penetration through the wall, through the ceiling, all the penetrations where the electrical goes through the studs, through all the wiring that we've got, because we're just stud walls right now. So we have to, all the way up into the ceiling, all those have to be patched just to make it not like airtight, but to make sure that there's no path for insects or moisture or anything else to get through. Brit Stick, welcome to the gallery. Thank you so much. Love that you're here. I appreciate being a member as well. Hope you enjoy the perks of membership, including all the emojis, which we have many. We haven't made an emoji in a while, so we'll have to think about a new emoji here soon. We did hit. Did we hit 22,000? We hit 22,000. We did it. Oh my goodness, we did it. Woot. I thought it was going to happen tomorrow. This is, hang on one second. Let me, I have to, just for the end of the stream here, give me just 1 second. I'll turn off that and turn on the one noise. You guys know where I'm going with this one. Wait for it. Where is it at? Why is it so small? Why is it so blurry? Why are all the words so blurry? There it is. Boom. On, refresh. Now we're good to go. And turn that back on. There's the party sound. So we hit 22,000. Thank you, Sharon. I appreciate it. We hit 22,000 under your watch, Sharon, with your careful eye and guidance on the internet. That is just awesome. Can anybody find us 2 more somebody to love? Find me somebody to love. That's a good song, Rudy. Another earworm that's now going to be stuck in my head.
Super sticker with 3.3.
How does judge decide what witness is shown? Leanne, I believe the judge probably communicated with the lawyers, and the lawyers who called the witnesses expressed a willingness or desire to not be on screen, and he just allows it. So we're getting about a third of the witnesses shown currently, maybe a little bit higher than that. As we get further into the case, there's going to be more police officers. Those, I think, will all be shown us. We're talking about the evidence. We talk about the firearm tool marks, the ammunition, the damage on the house. All those are going to be all shown for sure. Did you ever track down the bug that was hanging out in the studio? Yes, Perry Mason caught it this morning. Found it high up on the wall. We have 11-foot ceilings here in the studio, and it was up on we have a picture rail. This is a really old house. There's a picture rail that sits about maybe 10 inches off the ceiling, and it was like crawling above the picture rail, sort of making a lap around the room. And it was in slow mode because the bug had obviously come through the outside of the house, where we have treated the house for bugs just to make sure, discourage them from coming in. And so it was probably not feeling well, and it was not climbing very well as they normally can climb like Spider-Man. But so it's struggling along, and I get the Raid, and I'm thinking, if I spray this, it's going to, and I use the lemon, by the way, lemon-scented Raid, or Febreze, Southern Febreze as we call it. If I spray this, it's going to fall, and as it falls, it's going to be like, oh no, I'm falling, and it spreads out its wings, and then it flies at the first person it sees. I don't know why they do that, but they do. They fly at you when they fall. And so I'm like, I don't want that. But then it fell on its own and landed on the back of my TV right there.
Congratulations to 22K subscribers. Party face with a party horn. Hat. And confetti party face with a party horn. Hat. And confetti party face with a party horn.
One more.
And
Okay.
confetti party face with a party horn.
Thank you very much, Angie.
And confetti.
Ooh, hat and confetti. There we go. I appreciate that. I think I missed a previous one just a minute ago. I think that was MCAT. Thank you very much for the thumbs up for the super sticker as well. It's exciting to every time we hit a new Thank you, Lost Souls. I think you put us over the limit. Every time we hit a new benchmark, it's super exciting. You guys are amazing that way. Anyway, the bug fell on the back of the TV, and I realizing that I had to spray, and there's sensitive electronics there. I'm like, I might short out the TV. Worst case scenario, I have to steal the one that's going to go out in the Airbnb for today. But I sprayed it and killed it. It fell dead on the desk, and my son threw it away. So, bug has been extinguished. Break out the water is what we're going to do. We're going to do breaking out the water. Carrie Brooke, thank you for being here. We'll be back here tomorrow for sure. We're going to follow. We hope that we have the video from today. I hope that starts dropping. Otherwise, we'll just have the one video. We might, in the afternoon, have to follow a couple of the little court cases that happen around the country as we're waiting for this video to drop, which by judge's order can't be live streamed, has to be delayed. But they're sort of slow on the upload of the delayed video. So that is awesome. Thank you, 80s Music Man. Appreciate it so much. You've been here for many of those celebrations. Didn't realize the attorneys were sitting that close to each other. That would be really uncomfortable. Same desk, Carissa. Exact same desk. They sit there on the. Let me fix everything here. Just one second. They sit there on the exact same desk. I don't know what's happening there. I messed something up. I'll fix it in just a minute. Run to A and run to A. We'll move everything back where it belongs for just a minute. There we go. Okay, now you can see me and we can talk. Same desk, and the prosecution, if they like glance over, they can see what the defense is writing. They're like elbow to elbow. If you have a lefty and a righty next to each other, they'd be like fighting for space. And that doesn't work at the dinner table or at the defense or prosecution table or combined table. So just funny that it's just something different that's happening. This is our first trial we followed in Illinois. Another thing about this trial that's a little bit different than others is that the judge is like, hey, while you guys are talking to this witness, I went out researching on the interwebs and I found some evidence. Is it all right if I show that to the witness? Because he's like, nope, I don't have any recollection of that. He's like, hey, I found it. Here it is. Can we show the witness? And he did. And both sides were like, yeah, we're cool with that. I mean, I guess that's normal here. I guess that's okay. I think so. Good times. Anyway, so lots of stuff here. Sue Magic, thank you for liking the stream. I appreciate that. That does wonders to help other people find us. That is just great. I have a fly assault rifle. It's, oh my goodness, Cindy's crazy. I want one of these. Like it's a bug assault. It's a bug assault. I think it's the actual brand. but it's like a little plastic toy pew-pew, a little shooter that you load table salt in on the top, and then you cock it, and it sends a blast of table salt at the fly, and you can exterminate flies using table salt. And it's a very clean and effective process, and it works, I think, better than the fly swatter. I have to look for one of those. Oh man, I want one of those. My kids would love it too. Thank you very much, KR. Appreciate that. Thanks for all the congratulations. I see a ton of them in here. You guys are amazing. Hop over to Brandy, let them know about your 22K. Go over and celebrate with them. Do you guys want to maneuver over to Brandy's stream? Would that be okay if I transition you? Let's see if we can do that here. I'm not sure if she has her stream up. She's live right now. Okay, yeah. So we can make a move over there as we're wrapping up today. But let's see. Haven't left, catching up on your streams this weekend. Sounds good. We have a podcast this weekend. Weather Watch and I are going to be talking about that. We already have some amazing stories to talk about. One of them is true crime starting them young. That's here in my own state, and you'll want to hear about that. It will probably shock and appall you. But wow, amazing. Let's see. We've got a couple more. See you later. The addict's leaving early during our 22,000 party. What's wrong with you? No, it's fine. They've got things they want to watch, and I can't blame them. If for some reason you're not able to, if you're done with YouTube for the day, and I understand if you are, we've had a lot of heavy audio today, and you're not able to join us over on Brandy's channel for a little bit. Please tonight when you go home. Wait. There it is. Please, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. We'll be happening tomorrow, I believe 9 a.m. tomorrow. 9. The big 9, not 9:30 anymore. No more sleeping in. That's over. That's a thing of the past. I'm turning over a new leaf. Early mornings are my thing now. 9 a.m. is when we're going to start. It'll be a blast. We'll have some fun stuff tomorrow as well. And it is Friday. It's Friday tomorrow. So we'll have the podcast in the evening as well to look forward to. Matthew Harris, whose shirt I am wearing right now, has dropped a new video today. Look at this. First of all, you should all be wearing a shirt just like this. I'm just saying. Everything I know about law, I learned from Matthew Harris Law. You can find that over on his channel. But you can also find on his channel a brand new video that tells you about how much money the airline should be paying you if you get bumped from a plane. If you get denied boarding on a plane that you paid and you have a right to be on. You'll want to watch that video because all of us travel, whether we like to or not. Sometimes we end up on a plane. So go over and watch that video as well. I highly recommend that. We're going to bump people over to Brandy's channel. She's live right now. I don't know where she's at in this hearing. This is the football player when she's watching. Let's pop over and say hi. There's a Sarah Boone hearing today. Sharon, are you sure? Today? I think I didn't think there was. I think there's a new letter. Well, we read the letter. Let me go back to Orange County. Let's see. There is a hearing today. I'm seeing it right now. Wow. Okay, I'll check out what that is. Thanks, guys. We'll see you guys tomorrow. Have a good one. We'll see you. Wait. There. Perfect. Nailed it. First try.